We'll get started in a moment, so if you can find your seat so long, we'll appreciate that. All right, welcome everybody. This is our final public hearing on the Copyright and Performance Protection Bill. So welcome, it's great to have you here for our final session in Cape Town. Before I jump into the swing of things, I just want to talk through a few house rules. So for our house rules today, you'll note that we have guests who are online. We are being streamed on YouTube Live, and we have guests who are in the house. For those of you online, welcome. Thank you for joining us. If I can please ask that you turn off your video and keep yourselves muted throughout the duration of today's sitting until you're called upon to speak, that would be greatly appreciated. And to those who are in the house, if you can please ensure that the speakers on your devices are turned off and also your phones are muted, just so that there's no interruption with the mics. When you do speak on the mic, just turn your mic on, and then you'll be audible to everybody in the house. It's very important for our own record keeping that you turn the mics on and then turn it off again. In terms of language, so we do have translators here, and we also have a sign language interpreter assisting us today. So you'll notice that there are headphones in front of you. For Afrikaans to English, you'll go to channel 2. For Xhosa to English, you'll go to channel 6. And then for Afrikaans to Xhosa, you'll go to channel 4.
And our view is
apologies to the online guest, if you can please mute yourself. Then we are waiting on Piketberg to arrive and to join us today, so we'll warmly welcome them as well. And I'm going to be extremely strict on time today, just as a result of us having so many submissions and so much interest. So I've got a timer here with me. That's how strict I'm being. And I ask that you please try and keep your presentation within 5 minutes, absolute max 10 minutes. And I will keep an eye on the timer to make sure that we don't go overboard. In terms of apologies, we've received one apology from member Isaac Seleko. Member Derek America has kindly joined in his place online. And with that, I just want to talk through the process. So we'll kick off with a presentation from the department. Then from there, we'll move on to our oral submissions. From our oral submissions, we'll then move on to final remarks. Before I hand over to the department, I would like to give the members online and in person an opportunity to introduce themselves. And perhaps I'll hand over to member van der Westhuizen.
Good evening, Chairperson, and good evening, everybody. My name is Andrikus van der Westhuizen. I'm a member of the Standing Committee on Finance, Economic Development and Tourism, the committee tasked with considering the input from the Western Cape on this bill. And I brought with me my assistant, Mrs. Kutsia. Thank you.
Thank you very much. And to our members online, if you could please introduce yourselves.
Good evening, Chairperson. My name is Derek America. As you've indicated, that I'm standing in for member Isaac Seleko. I am an alternate member of this committee. Thank you.
Thank you very much. Do we have any other members online? I see no members. With that, I'll hand over to Mr. Petja to introduce himself and to kick off with the presentation as well. Over to you, Mr. Petja.
Thank you very much, Chairperson, and good evening, honorable members. I'm happy to be here, and for the record, my name is Kadi Peje from Companies and Intellectual Property Commission, which is an agency of the Department of Trade, Industry and Competition. So I'm one of the team that has been involved in this legislative process to amend these two important bills. So, Chairperson, because of the time, allow me just to deal with the objectives of the bill, because all the slides in my presentation, they outline the policy objectives in the bills. So let me take this opportunity to thank you and honorable members for the opportunity afforded to the department and CIPC as an agency of the department. Can I just then flag my presentation with your permission? I know I have 25 minutes.
Mr. Petro, if you can mute your you can mute your computer or turn the sound off on your computer. Can we get ideas? Can we get ideas?
Let me just share, Chair. I think it's the wrong. Yeah, it's not there. Should I open it first? Like this.
Go back into Teams. And then go to machine. No. Leave that. I'm going to share it in.
No files.
Go to window. Okay.
Thank you, Chairperson, for the indulgence. Chairperson, honorable members, let me take you through the policy objectives of the Copyright Amendment Bill and the Performance Protection Bill. The objective of the bill is to build a legal framework on copyright and related rights that promote access to the works in a very balanced manner so that the interest of the right holders and the interest of the society at large are balanced. We are seeking to have that kind of a legal framework. But we also want to introduce the provisions pertaining to collective management of rights so that we have collecting societies that are governed in a manner that is transparent and able to discharge their obligations as collecting societies. We also want to come up with a legislation that protects the works and the rights of authors in a digital environment. As you can see, we will be putting the provisions of the WIPO treaties in the works that are owned by the authors. So the bill also provides for standard contractual terms so that we can empower the authors to approach the deals as they commercialize their works. This is necessary so that we deal with the historical challenges where authors were subjected to unfair contractual terms and end up losing their rights. We also want to introduce a resale royalty right, which allows the originator of a painter, as an example, to enjoy royalty when such works are sold to another person. But more importantly, and in the main, we seek to introduce the fair use system. Currently, we have a fair dealing doctrine, so we'll be migrating to a fair use system or a doctrine so that we can allow the public at large to have access to copyright works. But we're doing so mindful of the fact that we still have to protect the legitimate interest of the content creators who are the authors of the copyright. And you will see that when it comes to the sections or the provisions that deal with the rights of the authors, we have added or strengthened their rights in that regard, because we have provided for any kind of use such as communication to the public, making available, and also commercial rental, so that at least their rights are strengthened, and so that everyone who is using their work on communication to the public or making it available, they are able to continue to earn a revenue. We also want to provide for the sharing of royalty in respect of literary, musical, and artistic and audiovisual works. This is necessary so that we can prescribe how the royalties should be approached for the works that I've just listed. We also want to provide for the recordal and reporting of certain uses of works. The Collecting Society currently have a challenge whereby the users are not disclosing the works that they have used. This is necessary so that information can be given to the Collecting Society to know whose work has been consumed, so that they can pay the royalties accordingly and correctly. We also want to establish a copyright tribunal which will deal with all copyright-related disputes. Currently, the Copyright Tribunal has a limited jurisdiction, so we want to expand its jurisdiction so that it can deal with all copyright matters. And it should be established in such a way that it's accessible to the people, and it's also cheaper and quicker in dealing with those disputes. Another proposed amendment that we want to introduce is with regard to commissioned work. We want to make sure that as works are commissioned, those authors, those producers who produced the work should be given an access to those works by the people or the persons who commissioned the works if they are not using the works. So the legislative intervention there is to make sure that they have access to those works. We also want to introduce what WIPO treaties have always introduced or have in their provisions, which is technological protection measures. This is just a technological measure to make sure that the author is able to protect his or her work on a digital platform so that there are no obvious infringement. Chairperson, let me also take your House through the treaties that informs the bill so that they are aware that we did not just take these provisions from nowhere, we took them from the provisions of the WIPO treaties. So the WIPO treaties that form part of the bill are as follows. The WIPO Performance and Phonograms Treaty, commonly known as WPPT. This treaty deals with the rights of two kinds of beneficiaries in the digital environment. The performers, who are your actors, your singers, your musicians, etc., and the producers of phonograms, commonly regarded as or labeled as record labels. The other treaty that is also part of the amendment is the Beijing Treaty on the Audiovisual Performances, which deals with performers in audiovisual performances. We have proposed those provisions in the bills. We also put the provisions of WIPO Copyright Treaty, which deals with protection of authors of literary and artistic works, such as writings and computer programs. It is often called Internet Treaty, so that we can deal with the digital environment. And we also put the provisions of Marrakesh Treaty to facilitate access to published works for persons who are blind, visually impaired, or otherwise print disabled, so that we can also facilitate access to published works for those kind of disability. And then lastly, it is the Berne Convention, which has always formed part of our copyright legislation, and for which South Africa is also a member. So that's how we have approached the amendments in the two bills. Because of time, I won't be able to take you through the entire presentation because it's about 50 slides, but all these objectives, there are detailed in the slides, but it suffices to then allow the House at large to engage us on the policy objectives of the two bills. Thank you, Chair.
Thank you very much, Mr. Fetcher. We really do appreciate your brevity, but also the conciseness that you provided the presentation in. So we'll now move on to the oral submissions part of the program. I just want to remind our speakers, whether you're online or in person, if you can please say your name and where you come from or the organization that you're representing today. I also want to remind you that we are going to keep a timer to make sure that everybody has an opportunity to speak. So if you can try and keep your presentation to 5 minutes, no longer than 10 minutes, please. And I will indicate if you have run out of time. Then we will have, of course, guests online. Just a reminder to our guests online, please keep yourselves muted and keep your videos off if you're not speaking. But when called on, please do unmute yourself and turn on your video. So with that mouthful, I am going to hand over to our first guest. Our first guest who will be making a submission is Professor Owen Dean, and he is online.
Good afternoon to you, Madam Chair, and I'd like to thank you for this opportunity of presenting my point of view to this hallowed audience. I do have a slide presentation, which I'll attempt now to share.
Professor, I can confirm we are able to see your presentation.
Okay, let's just see. All right, so it's not moving forward. Okay, so who I am, I'm Owen Dean. I'm a practicing attorney. I have practiced as a specialist copyright attorney for the past 50 years. I am an emeritus professor of law, specializing in intellectual property at Stellenbosch University. I'm the author of a textbook on copyright law, the Handbook of South African Copyright Law, which is the standard textbook used throughout the profession and by the courts, etc. I've been described by an eminent former judge of the Constitutional Court as the doyen of copyright in South Africa. So I really do humbly submit that I know what I'm talking about when I talk about copyright. Now, there are serious deficiencies in these bills. Firstly, they are of a substantive nature. I'm not going to talk about that. I participated with Professor Sadula Kajika of Stellenbosch University in doing his presentation made on behalf of the Chair of Intellectual Property Law, and I fully support everything he said. I also support everything said by the South African Institute of Intellectual Property Law, of which I'm a member and I'm a past president. What I'm going to talk about are the technical defects in the bill. They relate to the draftsmanship and conformity with legal principles, including constitutionality and rationality and intelligibility. The technical issues are, firstly, that the bill is poorly drafted and contains many technical defects. At least 30 have been identified. In fact, I did a count this morning and I actually found that I've identified over 60 deficiencies. These are of a technical nature. Either they don't make sense or they are contrary to legal principles, contrary to the past case law, etc. The bill does not comply with the Berne Convention and the TRIPS agreement in several respects. It is though we are legislating the first draft of a document. I want to illustrate my point by reference to the Blind South Africa case. Now, this was a case which was brought because of the delays in the bill, having been referred back to Parliament by the President. Blind South Africa decided that they urgently needed an exemption or exception in favour of people with visual disabilities, and they went to the court in Johannesburg and asked the court to read into the current Copyright Act, unamended Act, Section 19D of the bill, what is proposed to be put into the Act. The purpose of Section 19D was firstly to create an exception for the blind, and secondly to bring our law into line with the Marrakesh Treaty so that we can accede to the Marrakesh Treaty. So Parliament passed this section as being good law. Their legal advisors, the members of Parliament, everybody thought it was absolutely perfectly fine. However, when the case came before the Constitutional Court accepted an argument which I presented as what is called an amicus curiae, that it actually didn't do the job it was supposed to do. It was common cause on the part of everybody involved in the case that the blind deserved an exemption or exception, but the only issue was whether the Section 19D delivered the goods, whether it did the job. The Constitutional Court agreed with me that as it stood, it didn't make sense and it didn't do the job. It consequently redrafted the section as an interim measure, pending further developments. But the point to be emphasized is that the Constitutional Court held that Section 19D was defective and unfit for purpose, despite the fact that Parliament had approved it. So Parliament missed the point, missed the boat. Now, this exercise or this instance is confirmation of the defective draftsmanship and defective text on the bill which I'm talking about. It is exemplary of other numerous flaws in the bill to which attention has been drawn. I have submitted a document in which I've outlined all of these gremlins. Now, Parliament has a duty to the nation to make good, sensible and unblemished laws. Parliament's legal advisors share this duty. Passing the present bills, and I include the Performance Protection Bill, with known defects will abrogate these duties and would be unconscionable. Parliament will not be doing its job if it knowingly passes bills which are defective. Now, copyright is a technical subject. That is a quotation from a South African court case. Truly expert knowledge is required to draft copyright legislation. The drafters of these bills have evidenced deficiencies in this regard. Section 19D is a case in point. They said it was fine and was perfectly good. The court said it was a lot of rubbish. It is necessary for the bills to be referred to a drafting committee of properly recognized experts for redrafting. And by that, I mean people who have worked with copyright, don't sit in ivory towers and read about copyright and write articles about it. People who've been at the coal face and have actually enforced copyright. What are the consequences of passing defective bills? Our law of copyright will be seriously compromised and the rights of creative persons will be vitiated. If the Act doesn't do the job it's supposed to be doing, then nobody's being benefited. The integrity of Parliament will be impaired. What will happen to Parliament's reputation if it produces legislation which it knows to be flawed? International treaty obligations will be breached. The acts will be unconstitutional, will certainly be challenged in the Constitutional Court. You can take poison on the fact that if the bill goes through in its present form, there will be a constitutional challenge. Thank you for your attention.
Thank you very much, Professor. We'll now move on to our next speaker or oral submission. That will be Douglas Scott and Corley de Kock from Wikipedia.
Cool. Thank you very much. I'm going to give it a few seconds to load up. Excellent. So I'm going to start off quickly with a brief background about who I represent, where I'm coming from, and that'll give greater context as to why I'm here today presenting to all of you on the issue of copyright and why we care so deeply about it. So as introduced, and thank you very much for the invitation to speak. It's always a great honor. I'm Douglas Scott. I'm from Wikimedia South Africa. We represent Wikipedia editors in South Africa and Southern Africa generally. We're a non-profit membership organization, existed since 2012. We primarily exist to promote the free knowledge movement. It's important to note here two things. Wikipedia editors, we are unpaid volunteers. And the second one is when it comes to copyright, we take the strictest possible interpretation of copyright law when it comes to our use of copyright in the Wikipedia world. And that is to protect the free knowledge movement, that is to protect the Wikipedia project, right? So we do take copyright very seriously. And now, the reason why I'm here today, or the two issues that we really care about as Wikimedia South Africa and Wikipedia editors broadly in South Africa, and this is why we support the bill that's before us, the Copyright Amendment Bill, is because it's got two things that we really like. The first one is freedom of panorama, and the second one is fair use. And this slide that you should be able to see doesn't seem to be showing the slides there. Okay, I'm going to revert here. This slide that you can see now in front of you best summarizes the #1 reason why we support the bill. It's because it's got something in it called freedom of panorama. It gifts South Africa with freedom of panorama. What is freedom of panorama? Why should you care? Freedom of panorama basically is a copyright exception when it comes to the ownership of the visual representation of a public work or like a public work of art, for example. So in our case, it came from a competition we wanted to host. Wiki Loves Monuments competition back in 2012. We really wanted to celebrate all of South Africa's heritage, all of South Africa's monuments, right? And so we requested that individuals, take photographs of all the monuments in South Africa, submit them to Wikipedia for use to illustrate Wikipedia articles. Great. A week in, we were told by one of our members correctly that what we did was wrong. We can't do that. We can only accept photographs of colonial era monuments, which is why you'll see on the side of my screen there's a screenshot of the Rhodes Memorial. Rhodes Memorial is illustrated with a photograph of the memorial, but we cannot accept photographs of recently built monuments or erected monuments, works of art, public works of art. It's very important to mention it's publicly located. Things like sculptures or the facades of buildings. And that is why the photograph you'll see on the left has got a doctored or censored image of the Nelson Mandela statue in front of the Union buildings. Is because only by censoring it can I share that image in confidence on Wikipedia and on Commons, right? And that is because although I own the copyright to that photograph, although the person who took the photograph of Rhodes Memorial owns the copyright of the photograph, when it comes to recently built monuments, we don't have the right to, it's unclear in South African law whether we have the right to share that image freely over the internet, right? There's no exception for that. In the case of old colonial era monuments, it's not a problem. The copyright has expired. In South Africa, we have 50 years plus life of the author. With more recently built monuments like the Nelson Mandela Memorial, it is a problem. We can't share it, and we exist in a very similar situation as in Sweden. In Sweden, there's a public fountain erected in a public space. It's owned by an institution. Someone took a photograph of that fountain. The institution sued them. Wikimedia Sweden represented them in court. Wikimedia Sweden lost, and they had to pay the equivalent of 2 million rand in penalties for taking that photograph that they owned, sharing it on the internet to illustrate Wikipedia, right? And that's because Sweden also doesn't have a freedom of panorama clause. This bill has got one, and that'll fix the situation here. A good example of that, which is very local to where we are right now, if you go down the road outside the legislature buildings, by the cathedral, the Anglican Cathedral, you'll see there's a recently built monument, the Archer's Ark, which is the Desmond Tutu Memorial, essentially. If you take a photograph of that, keep on your phone, that's fine. But if you share it on Facebook, Twitter, Instagram, TikTok, Wikipedia, whatever, problem. You open yourself up to possible litigation because the owner of that monument could, in theory, it's unproven in South African court, but it is possible, like in the Swedish situation, could, in theory, demand royalties from you. And we need protection from that so we can avoid criminalizing vast sections of South African society. So that's the main reason why we support the Copyright Amendment Bill. The secondary reason is fair use. We like fair use, and there are essentially 5 reasons why we like fair use. The first one is a lack of fair use only serves to further status quo, where the rest of the world can freely use and benefit from the work of South African creators. But South African creators can't do the same. In other words, the rights of American artists to make derivative works of South African content are greater, and they're more free to do so than South African artists are when they're making derivative works of American works. And having a fair use clause resolves that problem. Fair use at its heart protects publicly beneficial uses of copyright work. Again, another reason why we support it. The introduction of fair use in this bill allows South Africans to be better protected when they choose to use both domestic and foreign copyrighted works in their art criticism, reporting, and research. This includes on Wikipedia, where fair use plays an important role in contextualizing facts, illuminating knowledge. And we want South Africans to be able to share their knowledge with the world, and fair use is an important part of doing that. Not just on Wikipedia, although Wikipedia is what we really care about, but also broadly in other media too, sort of in the newspapers, on YouTube, on many other platforms and sources, right? It gives individuals more freedom. It's also good for development of domestic technology companies. It is, in my opinion, correctly described as the secret source of American technology development, American technology competitiveness, right? European Union, they often wonder why they don't have their own multi-billion-dollar technology companies, or at least as many as the United States. Fair use is often cited as a very big and important reason why the European Union countries, which don't have fair use, don't have these technology companies, whereas America, who invented fair use, does. America realizes this, which is why America has been very cagey about about other countries adopting fair use, which is their own legal invention, right? So when Israel attempted, which Israel, by the way, has got the same legal history, very similar legal history, South Africa being a former British colony. When they tried to move from fair dealing to fair use, the United States fought them pretty hard. The Israelis essentially overruled them eventually and have adopted fair use. And the reason why is because the Israelis, along with the Singaporeans who did the same, and the Sri Lankans, who've got an even more similar legal history to us, they actually use Roman Dutch in the same way we do, Roman Dutch law, have all adopted fair use, moved from fair dealing to fair use, because they know that it's the secret source of technology development and incubating technology companies. Therefore, for these two reasons, because it's got fair use and freedom panorama, we support the Copyright Amendment Bill and ask that you do as well. Thank you.
Thank you very much, Mr. Scott. So we'll now move on to our next presenter. Our next presenter, I believe she's in the house. It's Denise Nicholson, who comes from Scholarly Horizons. Is Denise here? Okay. Denise, are you online?
Hello, yes, I am. Sorry, I'm just trying to share my screen. I just can't find it on my, it's on my display, but I can't pick it up. I'm not picking it up from my desktop.
Denise, everybody who has joined us in the house does have a hard copy. So my suggestion is perhaps that you can continue with your presentation.
Sure.
And
Okay.
in the meantime, we'll try and flight it from our side.
Okay, I'll do that. Thank you. Good evening, everyone, and especially chairperson and committee members. I'm Denise Nicholson, a specialist copyright librarian from Scholarly Horizons in Gauteng, who also does work in your province. I'm honored to speak to you today. Thank you for this opportunity. As time is limited, I will only just talk briefly. I won't cover my entire full presentation. The Copyright Amendment Bill, or CAB, is an extremely complex but progressive bill that will quantum leap South Africa's copyright law into the 21st century and the fourth industrial revolution. The DTI prudently examined, then adopted or adapted appropriate and progressive laws and copyright exceptions of many countries, including the US, UK, EU, Singapore, Germany, Israel, and others, as well as WIPO treaties and proposals for treaties by the Africa Group and IFLA, and the Eiffel Model Copyright Law. It also commissioned studies and the Copyright Commission Review. It was guided by international and regional research reports, as well as the SA Open Copyright Review. The Bill of Rights, the NDP and SDGs were also key issues, as was the 2015 Cape Town Declaration, when South Africa and 13 other African countries committed to encourage the implementation of fair and balanced copyright laws to facilitate access to information for all. For many years, South Africa has strongly supported the Africa Group's proposals at WIPO for a treaty for libraries, archives, education and research, yet its national law does not reflect this. This is a contradiction in terms which the CAB will rectify. South Africa is a global player and is committed to international agreements. Instead of reinventing the wheel, it is commended for being proactive and for tapping into this rich trove of useful resources, all drafted by copyright and other experts around the world. In September 2022, the Constitutional Court declared the Copyright Act to be unconstitutional regarding visually impaired people. It is arguably unconstitutional for other reasons too. The CAB will remedy this. Based on the said framework and expert opinions, I've given you links on the slide, the CAB is compliant with international commitments. In the review process, no evidence was submitted to the contrary. No WIPO or WTO dispute mechanisms have ever been activated against any country with similar provisions to those in the bill. Fair use is not only in the US copyright law. Other countries are listed on my slide, which I can't get into at the moment, also have adopted fair use. There's about 11 or 12 other countries that have fair use, or call it fair dealing, but apply the fair use factors. So hybrid models are not unusual. Fair use provisions in the CAB are innovative and are not broader than other fair use countries. They give some examples and helpful clarifications for information users that reflect global trends in interpretation and assessment of any use not specifically authorized. Whatever can be done in Section 12A can also be done in the US and other countries with such as or including in their fair use clauses. Kenya has shifted from fair dealing to fair use, and Canada is moving in that direction too. Nigeria included such as and fair use factors in its recently passed bill, but still calls it fair dealing. I've given you links in my presentation to recommendations made on fair use by Australia, Canada, and New Zealand. Is fair use an enabler? Well, fair dealing is limited, inflexible, and doesn't address the ever-changing digital environment. Nowhere in the world is there empirical evidence that shows that fair use destroys creative industries. Despite doomsday warnings of a catastrophic nature, publishers, authors, and creators continue to prosper in countries with fair use, so why shouldn't they in South Africa? In the US, fair use contributes trillions of dollars each year to the economy and provides millions of jobs, and I've given a link on my slide as well. Everyone needs access to knowledge. Fair use is an enabler and will address ever-changing technologies, transformative uses, text and data mining, new innovations, 3D creations and AI, and unforeseen uses in the future. There are also many best practices or fair use guidelines that can help different stakeholders apply fair use when they do use copyright works. And again, I've given a link in my presentation. There's been much disinformation and myths circulated in the media about fair use and the CAB in general. Hopefully the resources I have provided in my presentation will help debunk many of those myths for you. There is strong support for the bill from international, regional and local organizations. Many of them actually made submissions. They've even presented at the US Trade Representatives hearings in Washington, DC in 2020. Some have also, as you've seen, and also in other hearings, have spoken at these hearings. I support the bill, and especially Section 12 and the following sections. Section 12B to D exceptions are very helpful and will transform research, teaching and learning programs, especially the digital world. The exception for course packs is welcomed. India and Canada also have similar exceptions. Many e-publishers now allow course packs as well. Savings on copyright fees can be directed to support university presses and local authors. Section 15 allows freedom of panorama as described by the previous speaker. Section 19B allows temporary digital copies. Section 19C, exceptions for libraries, archives, museums and galleries, will help all stakeholders and help preserve our cultural heritage. Also, authors can make their manuscripts open access if their research was funded 50% or more from public funds. Section 19D will stop discrimination against people with disabilities. It will need to be amended though, and Section 28P deleted, in line with the recent blind essay Concord ruling. It also extends to deafness, deafblindness, dyslexia, etc. Section 22A is costly and impractical. It should be rewritten to permit the use of orphan works for at least educational research and non-commercial purposes. Many of them use pseudonyms or are totally anonymous and they cannot be traced. And also many of the rights holders or organizations are defunct and no longer exist. Fair use will also apply. Sections 12D, 7E and 39B ensure that contracts will not be allowed to override exceptions in the future. This has been a practice for many years where where contracts have overridden lawful exceptions, and hopefully this will stop that practice. This comes from the Eiffel Model Law, but also Singapore's copyright law has this clause and the EU's Unfair Contract Terms Directive. Authors and creators will benefit from all the above exceptions too. The bill will also give them more control over their works, reversion of rights, moral and other rights, better contractual protection and fairer royalties. In the media, there have been many scandals about collecting societies or CMOs as it relates to musicians. Regulation will finally ensure transparency and accountability and fair practice, so authors, creators, performers and artists will receive fair royalties in future. I also support the Performers Protection Bill, which is interdependent on the CAB. The bills cannot be split into separate bills. Calls for the bill to go back to the drawing board are counterproductive. Many countries abroad have enjoyed similar exceptions for decades, so why shouldn't South Africa? Opponents of the bill ignore the huge investment made in time, effort, human and other resources, public inputs and hearings, revisions, the review, etc., to get the bill to the stage. We accept that no law is perfect, nor does every law suit everyone. It would be a serious failure of Parliament if this bill doesn't succeed after 6 years in the making and 14 years since its genesis. It is imperative that solutions be found in this current process so that the bill can proceed for assent to the President. Some issues can be clarified or specified in regulations once the bill has been passed. And in conclusion, the history of South Africa makes it a national imperative to build an informed nation, remove apartheid-era laws and inequalities, create self-reliance amongst individuals through access to information and technologies, as well as to build and sustain vibrant communities. The bill is long overdue. Further delays in the bill will have a costly impact on the economy, creativity and innovation, education and research, and libraries and other information entities by reducing the ability of citizens to have access to information, knowledge and research in the digital environment. Please act urgently to pass the bill, or else it will create an incongruent situation where South Africa's own copyright laws cannot do domestically what it is asking for at the international level, example at WIPO and the WTO. I thank you for your attention. And sorry about the presentation I wasn't able to share.
No problem at all. Thank you very much, Denise. We appreciate your submission. Thank you. We'll now move on to our next submission that is from Ben Cashton from Recreate ZA. Ben is online. Welcome, Ben.
Hello, hello. I hope you can hear me. Can you hear me?
Yes, you're audible.
Yes, audible.
I was expecting Artists Unite to be next, but maybe I got the, because we're both on the same link. But thank you so much for giving me this opportunity. I can go first. Recreate South Africa is a coalition of people who are creators and users of copyrighted material. We have involved in Recreate South Africa filmmakers and photographers and writers, but we also have those who consume copyrighted material, including educators and learners, and Blind South Africa is one of our affiliates. You've heard from them separately, I think, as well. So what we're trying to do is to unite everybody who is involved in the creative economy for fair, inclusive, and prosperous creative sector. And we believe that those things are not mutually exclusive. We know that over time in South Africa, over decades and centuries, in fact, we've had an intellectual property system and a copyright system that hasn't worked for the majority of South Africans. We have a copyright system where the creators want their work to be distributed and want to make decent livelihoods, and audiences want access. And in the middle, we have intermediaries, largely large corporations, that are assisting in the distribution of works, holding rights, and so on. And by that, I mean the publishers and the music companies and all of that. The problem is that we often have a skewed situation where the two sides, the creators and the users, fail to benefit. We have a situation where prices are high in the market, where, as we know, streaming services, books, music, all of those things that are copyrighted, all of those types of expression, are not returning good value to the creators, and at the same time, they're not well accessible to the majority of the population who need to access them. And we have to ask ourselves why. And for Recreate South Africa, the answer lies in this relationship, in the power relation with those who hold the majority of copyrights, but don't necessarily always act in a way which serves both the creators and the users. In short, we're supporters, very passionate supporters of the Copyright Amendment Bill and the Performers Protection Amendment Bill, because we think the package of those two bills addresses both the needs of the creators with fair royalties and the needs of the users with fair use and the other exceptions and limitations. We know from the beginning the ANC government nationally, the ANC majority government nationally, has done work on these bills and tried to introduce them. Then they were referred back to the president after lots of lobbying from around the world. We might want to dissect where that lobbying came from and why it is that large corporations joined up with governments in wealthy countries to lobby against our legislation. But I mention the ANC specifically because we know in the Western Cape legislature where we're presenting today that the DA is in a majority, and the DA has been vocal as critics of the bill, both bills previously. And we want to call on you to look beyond the criticism of the bills, which says that fair royalties is not good, fair use goes too far, that somehow it will damage the economy, that somehow the bills are not well drafted. That's a criticism we hear all the time. Well, no bills are perfect, but we've had lots and lots of other legislation that's helped us to start to return land to our people and ensure education and health and all of those things that were not perfect legislation. So this is not perfect, we accept. But I hope that you will accept that we need fair remuneration to the creatives, and these bills bring that in through all of the provisions that have been referred to before that ensure fair royalties for creators, whether they're writers, musicians, performers who have never had royalties previously. And the fair use ensures access for the majority of the population. What's the point in having cultural production by a section of the population and people can't access it? How do we create the creators of tomorrow? That's why we call ourselves Recreate, because we believe creators are all users. It's a cycle. In the best case scenario, it's a virtuous cycle where everybody can access that which is created and then can become creators themselves. So we ask all of you who are decision makers and legislators in the Western Cape Provincial Legislature to look beyond the critiques of bad drafting, which we think is a bit of a red herring, to look beyond those who say that it won't work, it won't be practical to remunerate artists based on legislation. We do it all the time. We remunerate people based on minimum wage legislation that I think all parties have supported in South Africa. So let's bring in fair royalties for creators, and let's ensure fair access for the majority of the population who need that in our legislation. We call on you to support the bills as they are in their entirety, and then let's go, once we've done that, into the next round of reforms. Let's not take another 2 years, 5 years, 10 years to take the very, very urgent step forward we need right now to have a more inclusive, creative economy. Thank you so much for giving me the time.
Thank you very much, Ben. Then from yourself, we'll then move to Artists Unite. Kaiser, Jade, Alec, Yoli, Mercy, Taylor, and Sydney Momosi.
Hi, everyone. All protocols observed. I'm Mercy Pagela, one of the South African female artists of the 80s. And I'm here to plead that the bill must be passed. It has been several years that this bill has been moving around. And looking at how we were exploited in our era, and looking at the bill today, and it covers me as a performer, and it covers the future generation. We were exploited because we never received royalties, and we were not paid royalties of the works that we've done. And our archives are international. The archives are owned by the international owned record companies, and it is in our concern that we get remunerated of the works that we've done then and get paid our royalties, because the Copyright Act of 1978 to 1998, it has covered the resale of royalties and the payment of the artist that were part and parcel of the wire or wireless sounds. So it is very imperative that we look into the brighter side of the heritage of the South African artists that is owned and kept in the archives of the internationally owned record companies. So we need to bring back that heritage so that we can have a legacy of our works as artists. I don't know whether it is possible for all the collecting societies to be regulated, because most of the time these collecting societies, they collect monies on our behalf, but those monies, when they come to us, there is nothing that is stipulated as how much have they made and how much have they collected, in such a way that we hardly receive statements from the collecting societies. And the other thing that I want to stress on this bill is that we need to the government needs to establish a performance tribunal, because there is so much that needs to be corrected from the past. And the only way we could do that is by having the performance tribunal, let alone the copyright tribunal. We need the performance tribunal so that we can be able to deal with the injustice of the past and the now and the future. And the other thing is that the creative arts fraternity is male dominated. Women are the ones that work harder, who produce music, who perform music, but women are not protected anywhere, even by managers, agents, record companies, and record labels. So if we can have in this bill a clause that covers and protects women's rights in the music industry. Thank you very much for this time. Please let the bill pass.
Hi everyone. There's an echo. Is that okay? Can everybody hear me?
Yes, you're audible.
Not sure why there's an echo. I'm not sure if it's also just on my side. Hopefully it will stop. So sorry about that. And also want to apologize our colleagues or the music legends, Sydney Mokgopodi and Ali Khawli are not here with us today, but we just had a few minutes. So we thought between Mercy Pakela and myself, we could definitely convey the core of our message, which is essentially that artists are still suffering under the current system. There isn't enough protections for them. They need access to fair royalties, and it's very important. It's very crucial, and it is really time that we, transform the economy and the law to really support creatives. But also, as Artists Unite, a big thing that we believe in is artists and communities uniting for fair copyright and fair royalties, and that these don't necessarily need to stand in opposition, that these can work together as goals for progressive legislation. We also believe that actors should be paid fair royalties, and that artists should have the rights to renegotiate their contracts if they are locked into unfair and exploitative contracts. That there needs to be a progressive balance between information and culture sharing and access and the protection of copyright owners. And again, that this can be done in a way that benefits copyright owners and creatives as well. And we believe essentially that the Copyright Amendment Bill and Performance Protection Amendment Bill do a good job of doing this and more. We believe that it's an emergency to pass these type of bills and that it's urgent, and therefore we are campaigning to say that they should be passed. And we also don't believe that we should be held ransom by major corporations who wish to continue a legacy of exploitation. We think that the conversation should move from just only, well, from a lot of perspectives, moving from just focusing on, strict copyright ownership to really acknowledging the importance of why we would need something like fair use in a country like South Africa, where the majority of people are in urgent need of access to educational materials and more, and where at the same time our creatives need protection. So we think this bill does a great job of balancing. There's definitely more, as Ms. Pakela said, we can start expanding the bill, looking at more ways it can help improve and protect our people. But at the moment, it is urgent legislation that is needed. There's been many years of consultation, and we think that it's doing a great job. And we think that most of the concerns that the stakeholders have been raising can be dealt with in the guidelines and regulations. So I just wanted to add that at the end. And yeah, well done. All the best for this process. And it's quite complex, and there's a lot of different voices to think of. So we hope that you also, think of the creatives and the artists that are in that are working together with communities to push for progressive copyright. Thank you.
Thank you very much to Artists Unite. We appreciate your submission. We'll now move on to our next submission. That is from Ohis Yakba. I believe that is in person from Voices of Africa Today. Ohis?
Oh, thank you. Good evening, ladies and gentlemen. Just want to greet the President, all protocols observed. First, I'd like to introduce myself. My name is Ohis Abdurrahman Yakubu. I am the Talents Manager and Public Officer for Voices of Africa Today, a non-profit organization whose focus is basically to support local talent, particularly musicians who lack the facility to create music. Our studios have been open, digital music production studios have been open since 2019, and our doors have been open to creators of music. We allow them to book free studio sessions on our website and allow them to use our studios for free. I am the sound engineer, and I create music for local talents. And in my experience creating music, part of my observation is that most musicians don't know anything about copyright. They lack basic knowledge about copyright. They're just actors. They're just acting in the industry without any basic information. And sometimes they even take instrumentals. They sing over instrumentals that don't belong to them rightfully, and which means that they can't publish or sell the music that they spend so much time creating. So in my work, I've spent a lot of time educating them, trying to make them think differently, and directing them towards knowledge about copyrights. But my comment today is really not has nothing to do about changing the bill. It's just a suggestion, perhaps for the government, to take a step forward to represent talents and creators because I think they are underprivileged in the fact every other industry has some kind of support from the government, except for musicians. They struggle a lot to gain fame, and when they do, the government tends to benefit a lot from them because they attract a lot of international tourism. But why can't the government just pay attention to take a step forward and stop allowing intermediary organizations collect royalties on behalf of? So our suggestion today is basically that the government might want to think about creating a platform to educate talents about copyright. First of all, I think that's the first thing that needs to be done. The government needs to step out and educate talents about copyrights, and also create like a platform where musicians can directly go submit their music and get a copyright from the government rather than because there are so many other bodies that issue copyrights to, and some artists copyrights one particular song with so many different collectors, and it's a confusing situation. At the end of the day, they get nothing. But if the government can create a platform whereby musicians can directly support content to the government platform at a minimum charge, even say 100 Rand or 300 Rand annual fee, and then through that, on that platform, the government can screen and say, okay, this content qualifies to go to SABC, where the artists can be guaranteed to get some kind of royalties from airplay, playlisting, and stuff like that. So that's our major comment for today. It's not a lot that I have to say. It's just a point that I like to make. Thank you so much for having me today, and I really appreciate the opportunity. Thank you.
Thank you very much, Ohis. And of course, the departments are in the room today if you want to speak to them a little bit later. I will now move on to our next submission. Our next submission comes from Sibongile Kwazi from SATU, or the South African Democratic Teachers Union. I believe Sibongile is present.
Thank you. I'm Sibongile Kwazi. And I'm the Provincial Secretary of the South African Democratic Teachers Union in the Western Cape. I'll just make a quick introduction, but the one who's going to give our submission is David Matsepe. As educators, we are supposed to be lifelong learners, and there are inhibitions to that. And COVID also taught us that teaching at schools can no longer be limited to the classroom. We've seen the changes in how education had to be imparted during the COVID period. And the Copyright Act, as it is, doesn't allow creativity on the part of teachers to give that education that is needed, especially during the times of disaster. I'll give over to my colleague. Thank you.
Thanks, PS. Thanks, Chair. Good evening to everyone. My name is Dr. David Matsepe. My portfolio is Head of Research at SATU. I'm also Research Associate at University of Johannesburg. So we as SATU, we align ourselves with a proponents of Copyright Amendment Bill, those establishments such as Wikipedia, Blind SA, Scholarly Horizons, as well as Recreate. So who is SATU? SATU represents approximately 264 teachers and education support personnel. We are also affiliated to Education International, which is the global trade union with approximately 32.8 million members across the globe. We advocate free, quality, and inclusive education for all, and in doing so, we are guided by Article 26 of Universal Declaration of Human Rights, as well as the Bill of Rights. Both instruments declare education as human right. So we see ourselves as revolutionary professionals whose fundamental task remains the total socio-economic emancipation of our people, utilizing the classroom as an effective site of struggle. In line with socio-economic emancipation and social justice, we pursue free quality education in that all children are able to realize their potential to participate effectively in the economic mainstream of the country in order for them to overcome poverty, which is part of a triple So in terms of current copyright law, we have noted that it is deeply rooted in apartheid education system. So that is why we are fully rallying behind the current, copyright amendment bill. We also realize that it fails to address the daily needs of our teachers, learners, and librarians by imposing unnecessary restrictions on access to teaching and learning materials. It also restricts the convention of teaching and learning materials to people with visual impaired, thus putting them at a serious disadvantage to those who are sighted. We have also realized that it perpetuates discrimination, the lack of dignity in our education system, contrary to the spirit of our Bill of Rights and other related international instruments, as I've already alluded, Article 26 of Universal Declaration. We are fully in support of a copyright amendment bill because we believe that one, it is aligned to our Bill of Rights, which declare education as women's rights, as I was saying, and it is the key to turning our backs on the past, dismantling the statutes of apartheid copyright legislation, and fast-tracking access to teaching and learning materials. It enhances access to and sharing of teaching and learning materials for face-to-face and blended and online learning, including distance learning, training, and lifelong learning. Meaning that if we may to pass this copyright amendment bill, we'll be able to access information such that we can be able to deliver the curriculum to our learners, and those learners, they can be able to participate, to realize their potential, thereby participating in the economic mainstream of the country. And as part of social justice, they will be able to overcome their families and themselves from stricken poverty. We have also noted, we also support this copyright amendment bill because it will bring about access to quality teaching and learning materials to realize and achieve knowledge contribution without any borders. And it will also promote convention of teaching and learning materials into accessible formats for teachers and learners who are blind or visually impaired to realize their potential. Our technical inputs on the sections of the bill are within the section 12A to D. Why am I saying this? Because these sections are purely on access to on promotion of access to information. In our context, the promotion of access to learning materials for teachers and learners. So in my conclusion, I will say change is painful but necessary. The time for CAP is now. Our economy needs this CAP for creativity and innovation. With those words, I thank you, Chair.
Thank you very much to the representatives of SADTU for the presentation. We'll now move on to our next presenter. Our next presenter is Christa de Klerk and Busi Makari from Blind SA, and they have joined us virtually. If I can hand over to Christa and Busi. Can I get confirmation from either Christo or Busi that either are online? Christian Busi, for the sake of time, I'm going to move on to the next presenter, and then you can perhaps come in to present afterwards if you are having any technical challenges. The next presenter is Penny Lane from Oxford University Press. Penny should be in the house.
I am Penny Lane, and I'm representing the Publishers Association today, and particularly I'm particularly representing the educational publishers. The South African publishing sector invests in the production of knowledge and the development of educational materials and technologies. Excuse me, I'm just going to have some water. We seek to support the success and capacity of teaching staff, learners and students, and we contribute to innovation, research and academic activities. Our work supports inclusion, educational progress, and the development of indigenous knowledge structures and languages, which are essential elements for social, economic and technological progress. Our first concern is that the Copyright Amendment Bill has been drafted and tabled without the foundation of a proper socio-economic impact assessment or an appropriate intellectual property policy. As a matter of sound governance, it is fundamentally essential that there should be well-informed understanding of the potential impact of the bill. The provisions in their current form will have profound effects and very far-reaching social, cultural, and economic impact. A private impact assessment that was conducted by PricewaterhouseCoopers indicates that the consequence of this bill's overbroad fair use provisions and copyright exemptions would be a very significant decline in local trade of educational books and materials, resulting in diminished economic viability of the publishing sector. So very simply, without a fair financial return on investment, the publishing sector cannot have the financial means to produce the educational materials that we currently provide. For many South African educational publishing businesses, this diminished return will inevitably result in significant restructuring, retrenchments, and in some cases, business closure. We would expect at least a 30% decline in employment within the sector, which predominantly employs Black women. We are deeply concerned that this impact assessment has not been taken into account by government decision makers. We receive reports from schools, higher education institutions, and student representative bodies that learners and students continue to rely upon textbooks as a crucial element of their learning success. During the COVID pandemic, books and educational materials were absolutely crucial for learners and students who were forced to continue their studies in isolated and remote learning environments. But if the bill's fair use provisions and copyright exemptions are implemented in their current form, there is no doubt that there will be very few local educational books and materials available. The volume of well-curated educational materials that are relevant to the regional context and designed to address the unique learning needs of our own learners and students will significantly decrease. There will be far fewer educational books in mother tongue languages. Instead, reliance on imported publications will increase at a much higher financial cost to users. This means that there will be a far greater dependence on imported knowledge production, and that South African creative exports will decrease. During previous years, we have worked hard to support the transformation of knowledge within the region and to ensure that educational materials are relevant to the specific context and learning needs of our learners and students. If these materials are no longer available, there will be a decline in learner and student throughput, as well as in regional innovation and growth. There will be few South African publishers to support the development of indigenous knowledge, which should shape and build the social and economic future of our country. And there will be less diversity in the local voices that shape our knowledge and our future. It need not be stated that socially and economically this would be catastrophic. The challenges within the South African education system are deeply complex. These systemic issues demand cooperative investment and contributions from many stakeholders. As you would know, investment and contributions from the private sector is absolutely vital if we as a nation are to address the deep-rooted issues within our region. The lifeblood of this country's future lies within education, and the educational sector is very much in need of additional capacity, support, and investment. The members of the Publishers Association of South Africa are deeply committed to supporting inclusion, educational efficacy, knowledge development, and innovation within the sector, the educational sector. We are also concerned that while the stated purpose of the bill is to ensure that creators' economic interests are supported, the bill does contain measures that undermine authors' potential royalty earnings. Section 6A of the bill, which is concerned with enabling fair reward for authors, must be viewed together with the provisions that provide for overbroad exceptions to copyright protection and widespread unremunerated use of creative works. The latter provisions fundamentally undermine creators' interests. We're concerned that within the global environment, South African authors, creators, and publishers will have less legal protection than their counterparts in developed regions of the world, and that this divide will create entrenched structural disadvantage for both creators and users of local knowledge. We have set out detailed proposals that address specific concerns in a constructive manner, and we would be pleased to provide a detailed document that expresses these recommendations to the Chair. However, a more meaningful, thorough, and preferable approach would be a fundamental revision of the bill, taking account of proper research and a sound intellectual property policy. And for the sake of our economy and of the social and educational success of our youth, we earnestly urge you to consider the latter path. Thank you.
Thank you very much. We do appreciate your submission. We'll now move back to Blind SA. I see that Christo and Busi have managed to resolve the technical issues.
Good evening. Is this the echo?
Good evening.
Crystal, I think you have double screens on, that's why you're echoing. I'm not sure if you are connected to two sets of devices. Can you try and disconnect one?
I can try.
Good evening, everyone. May we please having the sharing rights because we want to share our presentation on the screen.
Can I suggest, just for the sake of time, I'm not sure what the technical issue is there, that perhaps you proceed with your presentation and then we will flag your presentation from our side. That's an order?
Okay. Thank you. Krista, can you please unmute yourself? We are unable to hear you because you're still muted. Thank you, sir. Apologies, ladies and gentlemen, for that.
Hello.
Welcome back, Krista.
Am I audible?
Yes, you're audible.
Good evening. My name is Krista Ritlat. I am the Vice President of Blind SA. And I'm presenting a much condensed version of our submission that we've already made in the interest of time. The full one has been submitted together with our written submission and the judgment of the Constitutional Court of 21 September last year, as well as an explanation of the Constitutional Court judgment by Section 27. Now, on the next slide, we have the logos of the two organizations concerned, Blind SA and Section 27. Now, Blind SA is a national non-profit organization with some 46 branches across all 9 provinces of the country. It strives to empower blind persons in every aspect of their lives, from birth all along their lives. So this matter is of particular interest to us. Section 27 needs no introduction. We acknowledge them, we thank them for their great assistance in our victory. We are proud to be associated with them. They never lose their cases. Now, let us then look at our position, the public interest. We are strongly in favor of the CAB. Now, let me just for a moment deviate here to deal with a matter that has come to my attention that Professor Karl Jeker of Stellenbosch on these forums is repeating a mantra he started 2 years ago already, that proponents of the CAB are using the blindness community to promote their case. We categorically deny that. In fact, we take offense to that. It is an insult to us because it suggests that we are not capable of understanding that we are being used, that we lack the mental capacity. We are sure that you will not be persuaded by any such nonsense. We support the CAB because it is in line with constitutional and international requirements. The Constitutional Court judgment that I will deal with later actually suggests some small modifications to Section 19D of the CAB. Our presentation, that was a written presentation, outlines those, but those are minor. It does not in any way mean that the CAB in its totality is unconstitutional. The language is in our written submission. We also need the other benefits of the current two bills. We need fair use. When a work of a literary work could be exorbitantly expensive, and then when a blind person needs it, that still has to be converted into an accessible format, which also costs money, so it increases the cost. And at least if we have fair use, it would reduce that cost. We need the performance protection bill because blind creatives also need their fair royalties. If we now look at the instruments that we are focusing on, those are the CAB, the Constitutional Court judgment, and the Marrakesh Treaty. Let's just now then consider the Constitutional Court process that we followed and why. It started from the book famine that we are experiencing. You know that less than 0.5% of publications are available in accessible format. What do I mean by accessible format? Accessible formats include Braille, audio, large print, and DAISY, which is an acronym for Digital Accessible Information System. The sighted person can immediately read a book that he or she purchased or borrowed. A blind person cannot. The book still needs to be converted into one of those formats. But to do that, copyright permission is required. And in our experience, we got the copyright permission in 10% of the cases for which we applied. In other words, 90% of publications that we needed to have converted into accessible format were refused to us, were not available to us. To take it a step further, I broke the law in order to become a lawyer. When I was studying and could not get copyright permission or couldn't get in time for books, I would use books from libraries, get others to make recordings onto tape. It still was in the early medieval times. And by doing so, I got the material, but I broke the law. That was against the law. Came 2013, Marrakesh Treaty. There was great jubilation in the blind world. We thought at last our rights are respected and we are now getting a copyright exemption so that we can make print accessible in the different formats we need. However, now, 10 years later, we are deeply disappointed and dismayed that our government has not yet acceded to the Marrakesh Treaty. The long dispute around the CAB has perpetuated the violation of our rights. That compelled us to approach the High Court. We litigated up to the Constitutional Court. And the Constitutional Court eventually found in our favor on the 21st of September last year, found that the 1978 Copyright Act was unconstitutional. It discriminated against persons with disabilities, violated our rights to equity, dignity, and participation in cultural life. We had to beg for these rights to copyright owners. The court rejected Professor Dean's contentions that the 1978 was constitutional. The court also rejected his contention that Section 30 of that act gave it its constitutionality, gave us what we needed. So the court rejected all his arguments. But the court did not grant our request that Section 19D be read into Section 28, into Act 1978, because it felt that Section 19 did not go far enough, it wasn't clear enough. So the court provided the necessary text to be inserted as Section 13A into the 1978 Act. It suspended the unconstitutionality for 2 years, giving Parliament 2 years to rectify the constitutionality, but at least it did grant us immediate redress, and we have the copyright exemptions we required. And now Parliament has 2 years to rectify, and that is why we are here to help you put Section 19D into the best format that would help us bring it in line with the court's judgment and the Marrakesh Treaty.
Apologies, Mr. Clark. You've gone over the 10 minutes. If I could ask you to please begin
summarizing. What the court provided as Section 13A of the 1978 Act is not a base. It is not. It is a baseline. It is not a ceiling. It fulfills constitutional obligations, but it cannot be made lower by legislation. It can only be made higher because, as I say, it's a baseline. It is not a ceiling. Now I get to our recommendations. The one about accessible formats, Braille, large print, the definition in Section 19D falls a little short, and it is recommended that it be amended in terms of the judgment. The text of the judgment and the Marrakesh Treaty would give guidance to do that. The next recommendation in respect of a beneficiary person, we suggest no changes to the CAB, as the CAB already adequately deals with that. The following recommendation in respect of a permitted entity, here the CAB falls a little short, and again it is recommended that the judgment, the text in the judgment be followed. The next recommendation concerns, this is artistic and literary works. Here our recommendation also is that no change be made to the CAB. The CAB would fulfill South Africa's Bill of Rights and international disability rights. The South African and international disability rights obligations. Next, the recommendation on technical and protective measures, TPMs. Let me just quickly describe the problem we experience here. When you buy a book, electronic book, it has an electronic lock, and that lock can tie the book to a particular device or to a particular application. And I know blind people who have bought books and then could not read them because of this protection measure. So the recommendation here is that Section 28P of the CAB be amended. We recommend that Section 28E2 should be deleted in accordance with the Constitutional Court judgment, as it restricts access to the publications. It discriminates against us by requiring us to obtain authorization from copyright holders. Then the language of other recommended changes to Section 28P is in the written submission. Then I wish to thank you for allowing us this opportunity to put our case to you. We I hope you will give it a positive ear. You know, we've been struggling, my own personal struggle with this has been since 2005. We have the Constitutional Court judgment, but you know, there are still some of our rights that are being violated, and we appeal to you to accept these two bills so that our rights can be respected. Thank you very much, and we are available for further consultations and clarifications. Thank you.
Thank you very much, Christo. Thank you very much, Busi. We do appreciate you taking the time to make the submission. I'll now call on our next submission, or our next participant. That would be Professor Peter Law, who's joining online. Professor is from the Department of Information Science from the University of Pretoria.
Thank you, Chair, for this opportunity to speak to you. I must clarify that I speak in my capacity as a researcher, an author, and a user of scholarly and academic literature. I do not formally represent the Department of Information Science. As a retired professor on that department, I hold an emphasize that when I speak of what I do as a scholarly researcher, I need to mention that research is not conducted in isolation.
Apologies, Professor. There seems to be something obstructing your camera lens.
Does that help?
There we go.
Okay, I'm sorry. I have two computers, and that's why I think this one was obstructed. Could you hear what I was saying?
Yes, you were audible and are audible.
Thank you very much. So I just want to emphasize that research is not conducted in isolation. One doesn't just create out of a vacuum. Research builds on the work of others. In my written submission earlier, I emphasized two issues that concern me. The first is the delay in ratifying the Marrakesh Treaty. Now, I was involved in a small way in actually the advocacy that resulted in the passing of that treaty back in 2013. I was the Secretary General of the International Federation of Library Associations and Institutions when that process started. And IFLA, my organization, was a partner of the World Blind Union and other interested parties to advocate for it. I find it personally mortifying that after 10 years and ratification by 117 states, my own country, South Africa, has failed to do so. This is a shocking disregard, I believe, of the human rights of a substantial minority of our citizens. And I fully support the plea by Chris to de Klerk. And I also share his concern about the inclusion of technological protection measures. The second issue which I would like to concentrate on is the critical importance of access to information and knowledge for our country's future. Access to information and knowledge is a precondition for quality education, for internationally competitive research and development and innovation. and the barriers to access that are enshrined in our outdated legislation that certain well-meaning parties seek to retain, if not to augment, prevent us from being internationally competitive. We are, as it were, fighting with one hand tied behind our backs. I'd like to flesh out more concretely this rather abstract statement by referring to my own experience as a so-called creator of content for the scholarly publishing industry. Now, if you will allow me, during a career of nearly 50 years, I've had approximately 200 articles published, most of these in international journals accredited by the South African Department of Higher Education. I have not earned a cent from all this work. From some of the smaller US publishers, I've occasionally received a small amount in the form of a check, like $30 for serving as an issue editor for a journal. Now, these you can do nothing with an American check, so I just cancel them and send them back and suggest them that they donated to a worthy cause. My work has quite often been prescribed or recommended by universities, and I'm aware that those universities' libraries have had to pay copyright fees to reproduction rights organizations or collecting societies, such as the Copyright Clearance Center, the CCC in the USA, and Delro in South Africa. I've never received a cent from any of these organizations, nor have I ever received any communications from them. I presume that the money goes to copyright owners, that is the publishers, and I'll note that most of these publishers are based overseas, so there's a considerable outflow of funds from South Africa to the USA and Western Europe. I wonder whether that's a good use of our currency reserves. I also may mention that I serve on the editorial boards of half a dozen domestic and international journals. I do a lot of reviewing. And for this time-consuming but essential task, which is necessary for peer-reviewed journals, we reviewers are not paid a cent. I wrote a 900-page book, which took me 10 years to write, my own fault. It was published in Germany in 2019 by an international publisher in a print run of 220 copies. That's not unusual, such a small number for specialized monographs. I've so far received 582 euros in royalties for this, which is, if you divide by 10, is not very large income per year. There's not much more to come. So from a business point of view, Chair, I am a dismal failure. But that's not why I write. The currency of scholarly authors is not money, but recognition, especially recognition in the form of citations by other authors. So it doesn't worry me that I'm not making any money out of my writings. My concern as a scholarly author is that my work should be read, appreciated, and used widely and cited, especially in South Africa. Publishers' organizations pride themselves on protecting me from piracy. I grant that such protection might be very important to the writers of fiction or popular non-fiction or undergraduate textbooks. But as a scholarly author, I don't care two hoots if my work is accessed by people in unorthodox ways. The more people that have access to my work, the better. And all the better if they can gain access ethically and legally without having to pay crippling fees. By locking up my content, the publishers are actually frustrating my calling as a scholarly author. So I conclude, the exceptions and limitations to copyright or the fair use provisions that are enshrined in the bill are essential for our students, our educators, our researchers to gain access to the scholarly literature that they need. The fair use provisions in the bill are no more liberal than the legislation that already exists in the wealthy countries of the North. This does not stop them from generating massive amounts of content and from having some obscenely profitable publishing houses. Why can we not have those fair use provisions in South Africa? So I support the bill. Thank you.
Thank you very much, Professor. I would like to welcome some of the ladies that have joined us from Piketberg. You're very welcome. And we'll now move on to our next presenter. Our next presenter is Thando Polisan. Thando is from Composers, Authors and Publishers Association, or CAPASO. and Tando is joining us in person.
Good evening, everybody. My name is Tando, as introduced. Thank you, committee. Thank you, Chair, for the opportunity to make oral submissions on the current copyright amendment bill. Our comments will be restricted to the copyright amendment bill. So I work for an organization called CAPASO, whereby we license, whereby we represent composers, authors, and publishers of the musical works. We represent over 9 million musical works, which are composed by our members. So with the current bills, we just want to highlight a few of the issues that we have as our contentions in relation to the current bill, as if passed as it is, we are of the opinion that it will be highly prejudicial to our members and the current rights holders of the musical works. So the current states, the current bill introduces fair use and fair dealing, which is of our opinion that the fair dealing raises the combination of the two raises fundamental problems because they are jurisprudentially incompatible. Fair use is wide and general exception, whereas fair dealing is closed and more specific list to exception. Currently, our legislation does not have enough remedies coached in the bills to make sure that the introduction of these exceptions will be able to protect the rights holders. For we know that the exceptions that are being introduced will enhance the exploitation will enhance the exploitation of the rights holders' works without fair compensation. Therefore, we propose that in the introduction of such exceptions in the bill, we propose that the remedies be extended to introduce statutory damages. This will also just alleviate the burden that the rights holders will have in terms of trying to prove that an infringement has actually taken place. The second proposal that we want to just introduce is the introduction of private copy levy to be instituted in our bills. This is also just because of the exceptions that have been introduced relating to libraries and archives without the three-step test being provided for within these exceptions. We provide that at least a private copy levy be introduced so that there's a balance between the exploitation that has been taking place and the fair remuneration for the rights holders for their works. And then just moving quickly, we are also just introducing, these are the recommendations are all in detail in our submission, our written submission and our presentation. So I'm just summarizing. Another point that we just want to highlight is the royalty definition under section 6A. Currently as it stands, it makes mention of a royalty having gross profits. So in light of that definition and that introduction, it means that even with the music users that exploit the repertoire or the musical works of the creators will just prove that they didn't make a profit, which will be another burden being placed on the rights holders. Therefore, we state that this will be highly prejudicial because it will mean that even when the work is exploited, there will be no compensation, and that will not be able to empower the rights holders as what the bill aims to seek. So in our recommendation, we state that the royalty definition, instead of having gross profit, it has a percentage of turnover where where it will be ensured that compensation for the rights holders is indeed made, because the calculation of the royalty needs to happen in the minutes that the work is being exploited. Another point that we just want to highlight is of orphan works, whereby we are recommending to the committee that this does not apply to the music industry such as CAPASO, because we already have in place mechanisms to be able to deal with orphan works, and any intervention by the Commission will frustrate rather than assist the process. And then we move on to section 22F. I'll skip 22C. I think that will be covered in the submission. 22F just introduces the commissioner having the ability to suspend a CMO. The regulation is introduced and it is welcomed by CAPASO. However, it should not be taken into a means that the very thing that the bill seeks to apprehend, it will end up being prejudicial. CMOs are mandated by the rights holders, which means the rights holders themselves have the rights or have the mandate to construe how the CMO is run. Therefore, we recommend that when it comes to the commission having such powers, that the members who are the rights holders themselves be consulted whenever the decisions are being made. We also proposed wording to be inserted in subsection 5 of the clause so that it can account and cover all our concerns. With that said, I would like to just give my colleague, Nick Matukis, to touch on further on some of the issues that are in the bill that we contend will be highly prejudicial to the rights holders. Thank you.
Sorry, sir, if I can ask you to start wrapping up so long. Thank you. Thank you very much. Appreciate the summary at the end. We'll now move to our next speaker. That will be Dr. Andrew Rens from Research ICT Africa. I believe Dr. Rens is in person. Dr. Rens.
Let me see if
Dr. Rens, you'll just need to put your microphone on and then mute your device.
and I'm going to be trying to share my presentation with you, but not seeing.
What we can do is we can flight the presentation and then you
control of
can
the
just
chat, right?
jump straight in.
So while we're waiting for that, I'll explain who I am. So I'm Dr. Andrew Rens. I am a South African researcher who works at Research ICT Africa, and I'm obtained my doctorate in copyright and education, research in copyright and education from Duke Law School in the United States. And I have the incredible privilege of every day getting to work on whatever the cutting edge issues are of technology and law. Not all to do with IP, not all to do with copyright, but unfortunately, research doesn't always pay well. So I moonlight as a copyright lawyer and do that practical work that Professor Dean was speaking of. And in doing so, in getting today, I get to bring both worlds together. I get to bring my practical day-to-day practitioner experience as a copyright lawyer together with the research I've been doing on AI. And so I want to talk about AI and copyright. I'm going to try again to, or my colleague.
Everybody will have a copy of your presentation, so you can jump straight in and then eventually when the technicals figure it out.
So let's start with AI. AI is a really, really important technology. And it's a recent technology. And frankly, the importance of AI has come into being since the Act was first drafted. We didn't know it was this important when the Act was first drafted. So some important uses of AI right now: protein structure prediction for drug discovery, medical image analysis so we can diagnose cancer, automated translation, fraud detection, automated image recognition of defects in manufacturing, predictive maintenance, supply chain demand forecasting. So let me emphasize again, AI is super important. Now, how is AI created? Well, what you get is a large corpus of input data, and this is used to train a blank neural network until it begins to produce the kind of outputs you want. That's then, for static AI, that then becomes a static model, an algorithm. And in the current iterations of the technology, we have systems where you can give a little bit of input data and the AI will then give you an output. That output could be a prediction. That output could be a categorization. So it could categorize an image as being of a particular kind. But perhaps the most interesting are AIs that produce an output that begins to resemble human creativity. They produce images and they produce text that looks like it's made by humans. This has taken the world by storm in the last 6 months. But its implications for copyright are vast. They're crucial, and they show why we need the right provisions in the bill to deal with the future. The last regulations made under Section 13 were made more than a decade ago. It's obvious that regulations aren't going to cut it. Now, I have in my presentation a picture that I generated from DALL-E, one of the AI services. And so if you have my presentation, look at it, and hopefully otherwise we'll see it in the slides. So I generated by putting in a prompt. The prompt was, an expert explains AI copyright to Parliament. And what did we get? We got a picture of someone who doesn't really exist, holding up some kind of writing and a symbol of a sun. I see they're putting up my paper, not my slides. In front of the White House.
Thank you.
And so that tells us lots of things, not directly to do with copyright. It tells us that the database on this has been trained, thinks that experts are white men, and it thinks that Parliament is in the global north. The other 4 images that were generated all showed Westminster, a white guy explaining to Westminster. So AI is also skewed. The AI being produced right now in the world doesn't reflect Africa. I want to speak briefly about large language models, and then we'll get into what this means for copyright. So large language models are trained on millions of inputs. So ChatGPT, if you've seen that in the news, it's been trained on millions, most of the internet in English, frankly. And the resulting algorithm can be fed very little new data, and it'll then predict what the next words must be. So you feed it a sentence, just like I felt DALL-E, a sentence that produced an image, but it could produce a bunch of text. But it's purely predictive. Some people have been so fooled by its human-sounding nature that they are starting to think it's conscious, etc. It's just a compression algorithm. It's not more. But what that means is that some tasks can be usefully done by AI, but at the same time, we mustn't let ourselves get carried away in thinking this is an intelligence, this is something that's capable of creativity on its own. So if you to produce a static machine learning model, what you do is first you get a big corpus of images or texts, and that probably involves some reproduction, maybe temporary reproduction. It might be okay under copyright law, it's not 100% clear. Then you do technical pre-processing. You're putting these images or the texts in a condition that you can feed it into your training algorithm. And that's reproduction. So that's probably the most likely thing to implicate copyright. But this is all machines doing this work. This is not humans using the work for anything which has been imagined until, a year ago. No copyright person who wrote, an article 10 years ago was thinking, oh yeah, and I'll definitely make money out of this thing being used to train a machine. Then we have corpus annotation that has involved some human annotating of the, so is that a derivative work? It's an open question legally. We have corpus redaction. Works get deleted because they don't fit in, and then we train the model. Create some software. Does this new software have copyright in it? And then we freeze the model, and then we feed things to the model that produces output. So we end up with 3 copyright questions. So I think just a couple more slides and you'll have caught up with me. Firstly, does use of a copyright work in training an algorithm infringe the copyright in the individual items in a training corpus? Second question, do the outputs infringe copyright in individual items in the training corpus? So in other words, do the outputs resemble one of the inputs, one of the thousands or hundreds of thousands of inputs so much that there's an infringement? Number 3, does the output have copyright itself? There's actually a question you see I haven't dealt with here because I don't think it's that germane to what we're doing tonight, which is, does the algorithm have copyright? Is there copyright in the algorithm? My answer, by the way, is no, because we've never given copyright in algorithms. So my 3 answers are, does use in the training algorithm infringe copyright? Maybe. We're really not clear on this in law, but we should make clear it doesn't. And the reason we should make clear it doesn't is because AI is a super important technology. Second question, do the outputs infringe copyright in individual items in the training corpus? So if there's a bunch of pictures, does DALL-E occasionally reproduce one of those pictures in a recognizable that way? So the people who studied this from a statistical perspective say it's very, very, very rare statistically. It's also not a problem for us because when it happens, it's an infringement. We've got existing law. It's an infringement under the 1978 Copyright Act. We're done. We don't have to worry. Number 3, does the output have copyright itself? Probably not. There's no human author. Some people have trained an algorithm, but do we give Microsoft copyright in every PowerPoint presentation? They've made a tool. Am I entitled to copyright in that picture just because of my little, I think, not terribly creative prompt? Doesn't seem like that's enough creative effort. So we should make it clear, though. Why should we make it clear? Well, copyright's intended as an incentive for humans to create. AI doesn't need that. There's already enough investment in AI. Microsoft put $1 billion into OpenAI, which produced ChatGPT. That was in July 2019. In January this year, they put another 10 billion in. There's enough money to train AI, at least outside of South Africa. There's a different problem inside of South Africa. AI processes aren't anything like human creative processes. They're probabilistic. And the companies doing AI outside of South Africa, what they're after is general purpose AI. They're not necessarily after something like copyright. Okay, most AI systems depend on a lot of other people's creative input. And when you have AI systems that mimic what artists create, then they undercut the ability of artists to make money. So I'm suggesting, well, Research ICT Africa is suggesting that we amend the 1978 Act to clarify there's no copyright in AI outputs. So in our longer written submission, we suggest language which will enable this. And we think it should also be clear that text, so literary works, music, audiovisual works, are only those things produced by human authors and not automated processes. I'm going to briefly ask for indulgence to make my second point. AI is a strategic technology. If South Africa doesn't pass an exception to enable using copyright works in AI, that will just mean South Africa doesn't develop AI. The rest of the world's moving right on and doing it. Big tech companies don't need our permission. They already have permission in thousands of images that people have already uploaded onto them, giving them permission under the terms and conditions. So they'll be able to carry right on if we don't have exceptions. Europe tried to write a narrow exception. It didn't work. The UK tried to write a narrow exception. It didn't work, and they're thinking of remaking it. What worked? The United States has the much maligned fair use. That's worked. They're the leaders in AI. So the thing that will enable South Africa to produce AI for the Silicon Cape to carry on being the Silicon Cape is to have an exception, and that exception is Section 12A. Apart from that, although, like Professor Dean, like every lawyer, I think I could write a better bill if the job had been given to me. Despite that, Research ICT Africa doesn't think it's appropriate to go and rewrite the whole bill. It's been through a lot. Our recommendation is keep the bill as is, except for the narrow additions around ensuring that we can do AI research and that we can exclude AI-made works from copyright altogether. Let's protect human authors. Thank you. Oh, and just my funding, to be clear, is provided by the IDRC. This is the Canadian Development Research Centre. So if you want to blame someone for my work, that's the Canadian taxpayers.
We'll move on to the next presenter now. Our next presenter is Ziyanda Buthelezi Ngobo. I believe that she's here in person today representing Netflix.
I'm here, Chair. Thank you very much. Good evening, Chair, and good evening, colleagues. My name is Ziyanda Buthelezi Ngobo, and with me today is Renee Viljoen, and we are from Netflix, and we'll be presenting the Netflix perspective today. Thank you very much for the opportunity to be here to participate in this policy dialogue, and we trust that our input will be helpful, and we trust that at the end of the process we will come up with legislation that is helpful to all stakeholders, that balances the interests of all stakeholders. So just to start off, an introduction to Netflix. Okay, sorry, technology is failing me. So those who may not know, Netflix is a streaming service. We are active and we provide our services to 190 countries around the world, and we're very proud of our 223 million subscribers who enjoy the content that we offer. We launched in South Africa in 2016, and since then, the Netflix service has enjoyed incredible support from South Africans, for which we are very grateful for. Our members around the world outside of South Africa really enjoy South African content. South African content enjoys extreme popularity around the world. We find that local titles, our titles, find affinity with people outside of South Africa, and our content is enjoyed by countries that you would not even expect would resonate with titles such as Blood and Water, such as How to Ruin Christmas. So we are so proud of assisting South African creators export their work to the rest of the world. And since we arrived we launched the service in South Africa, we are so incredibly proud of the investments that we have made in this country. We are feeling bullish about South Africa. We are optimistic about the prospects of our service in South Africa, and indeed about the prospects of the audiovisual sector. Just to name some of our investment milestones, for example, our investments in this country exceeds 2 billion that we've inserted in local content in this country. We have created in excess of 2,000 jobs of young people who work on our productions, many of them under the age of 35. So the youth demographic who are in desperate need of education. And of course, we hope to continue on this path. This is work that we hope to continue doing in South Africa. But we are concerned about the Copyright Amendment Bill. We are concerned about the proposals that are made in the Copyright Amendment Bill. We are concerned that it will encumber the investment that we've made in this country, and we are concerned that it will make it significantly difficult for us to continue on the trend and the trajectory that we are on. We must underscore that, or set the context and the scene of our submission today. We support the objects of the Copyright Bill. We support aligning South Africa with our multilateral obligations that our government has made at an international level. We support fair compensation. However, we are very much concerned that what is being proposed will result in unintended consequences and will be harmful to the audiovisual sector. we wish to emphasize that some of the proposals are taking a one-size-fits-all approach. What works in the music industry doesn't necessarily work in the audiovisual sector. And we are encouraging this committee to really take those concerns and those differences and those nuances into account as you continue with your work. So our concerns are threefold in the main. And with that, I will hand over to my colleague who will add a little bit of texture to what our concerns are. Thank you.
Thanks, Yanda, and hi everyone and Chair and Committee. Thank you for this opportunity. I'm Renee, an IP lawyer for Netflix, so it was my job to do a bit of a deep dive and to try and understand what are the practical implications of the proposals in both of these bills. So I'm just going to speak to the royalty provision to keep it short and sweet, but just to flag that we're also very concerned about the limitation of 25 years to literary and musical works, as in our analysis, kind of getting clearance again after 25 years to keep the content on our service would be too cumbersome. That would lead to that content being removed from our service, which would not benefit our viewers, but also the people who created those works. We call it a bit of a content cliff that would happen after 25 years just because of the burdensome effort in re-clearing all the rights to keep an audiovisual work on our service. To dive into the royalty provision, like my colleague said, that might work in some sectors, but applying a one-size-fits-all to the audiovisual sector will have severely harmful consequences. To illustrate it, if there is no revenue, there is no royalty. Let's talk about the amount of shows that gets cancelled, the movies that do not make any revenues from theaters or our service. In those cases, the performer will not get a royalty. There will be no payment. Also, from the producer's perspective, you need money to reinvest into new content. If you cannot fix a budget and there is no ability to reap off the success of some of the works and reinvest that into new content, that will translate into fewer opportunities for performers again. And producers will sit with fewer projects and less international support because we are not able to have a fixed budget for what something will cost, what a show will cost. And finally, if you think of this, the Netflix business model, we are not a theater that sells a ticket to see a specific show. We sell a subscription to a broad catalog of content. We are not able to attribute revenue to a specific title. We do not know why subscribers subscribe to Netflix, why they keep their subscription, and why they renew their subscription. We assume that it's the combination of all the shows we have that appeals to the subscriber. How will we as Netflix be compliant to paying a royalty on a revenue that we cannot calculate? With that, the royalty provision is out of step with international standards in the audiovisual sector and recent technologies. And imposing a solution that might fit in one sector will not work in the audiovisual sector. I want to stress the fact that royalties are not common in the international audiovisual sector. We operate in 190 countries and can confirm that introducing this in South Africa will put South Africa out of step with other competing markets and make South Africa an outlier internationally. I hope this is more clear of why we are very concerned about this. And I do want to again repeat, we support fair remuneration of authors and performers. It is in our competitive, we are incentivized to be the best partner to deal with, because that is the only way we can compete with the other streaming services for the best talent and the best content. The competition is intensifying all around the world, and we do want to be the best partner, paying very fairly. So we are completely incentivized to do that, but this will have unintended consequences and shrink the audiovisual sector. Thank you very much. Sianda, did you want to add? Sorry.
Thank you very much, Renee. In closing, Chair, I suppose as South Africans working for Netflix, Renee and I are both South African, this particular bill is very close to our hearts, and we just want to echo the comments and the submissions of stakeholders. Some of them are not represented here today, but the Independent Producers Organization, Animation SA, the local stakeholders who have also sounded the alarm on the material economic harm that this bill would create for the producer community. We want to echo those concerns, and we're equally concerned, and we encourage the committee to take a look at those concerns and revise the thinking. Thank you very much, Chair.
Thank you very much. Very brief. Appreciate it, ladies. So we'll now move on to our next submission, which comes from Salome Leroux. Salome is representing on behalf of the SA Institute of Intellectual Property Law, and I believe she's here with us in person.
Good evening, Chair, Committee, and colleagues. I am Salome Leroux. I'm a practicing attorney, a trademark practitioner, and a fellow member of the South African Institute of Intellectual Property Law. The Institute is made up of about 200 attorneys, all specializing in copyright and trademarks and patent and design. And our interest in the Copyright Amendment Bill is not on behalf of any specific stakeholder or any specific point of view. We looked at the bills from a purely legal perspective. The Institute has been involved in this legislative process from the very beginning. We have answered calls for comment to the draft bill from 2015, and we've been part of the process, filing submissions since 2017 all the way through to 2022. And so the reason I'm saying that is we've had insight in all of the versions of the bill, the previous versions, all the reasons that they were referred back and forth. And in this round, we have made a comprehensive written submissions where we have analyzed from a legal point of view most of the provisions of the bill. And it's quite a lengthy submissions. It's about 100 pages long. But it is broken down into different subjects so that each stakeholder can have a look at the subject that is of interest to them. So our submissions have, like I said, taken only a purely neutral legal view, and like most of you and most of the stakeholders that have made submissions, I think most agree that the current Act need to be updated, and it is overdue. I haven't found someone who has said something different. And the object of the bill is to protect the creators of copyrighted works and performers, and also on the other side to create fair access. After having assessed the bill, we have found that these bills are not going to achieve those objects, and that is as simple as that in their current format. So we support the object and we support the reform, but the current bill has many shortcomings. These range from non-compliance with international treaties and deprivation of property to ill-considered solutions to very real problems and some perceived problems, and then down to basic, simple drafting errors. So I'm going to just, like I said, our submissions is very comprehensive, and I do invite you to at least look at the ones that are of interest to you, the parts that are of interest to you. But I'm going to summarize the problems in 5 points. The first is the expansive and dispossessive copyright exceptions that goes beyond what it intended to do. The second is the insufficient protection of technological protection measures, which is very relevant, very important in today's digital society. And the third is, which was already mentioned quite a few times, is the statutory royalty entitlements of authors and and performers. These are well-intended, but poorly framed and seemingly based on erroneous assumptions. And the next one has also been mentioned quite a few times, and that is the reversion right that was meant to be a reversion right, but it ended up being a limit on the transfer of copyright in literary and musical works. And then lastly is the limitation on parties' freedom to contract, and by its indiscriminate contract override clause, which applies to the whole Act and all of the exclusions, and then the ministerial power to lay down certain compulsory terms for contracts. So this is just a summary of a myriad of problems that's in the Act, and we basically, in our analysis, reduced the reason for these issues to two factors. That, there's lots of factors, but these two, I think, stand out the most. The first one is the mistake of extrapolating the new rights and exceptions that was meant to apply to certain classes of works and maybe certain types of actions. And it was extrapolated to apply to too much, and it is tried one size fits all, which is not tenable. And I think one thing that demonstrates it the best is just listening to all the different viewpoints in this room tonight. And each stakeholder has a different way of creating copyright works, interacting with copyright works. They are interested in different types of works, and they're interested in different acts of copyright. So and when one stakeholder is given what they're asking for, other stakeholders are going to be prejudiced. So a one-size-fits-all is not going to work in a copyright scenario. And the second is, which is also demonstrated by the passionate way that everyone has participated in this process, and the fact that there's been so many organizations coming forward to say how this is going to impact them, and that is the absence of proper socio-economic studies that is supposed to be the foundation for the bill, especially a bill with these socio-economic impact. And that is also the reason why the bill is now again before you, because the president sent it back and it had to be reclassified because it does have this impact, and that is why it needs to go through this process on a provincial level so that everyone can have their say. So we understand that the Department of Trade and Industry say that they rely on studies that support the bill, but only one of these studies have been published publicly, and upon closer examination, we found that none of these studies support the copyright exceptions, and especially fair use. So the only study that was published is the Copyright Review Commission's report in 2011, and that report is the forerunner of the bill, and it contains proposals for legislative reform. It only recommends an extension of the exception for personal use. There's no other basis for the rest of the exceptions or for fair use in that report. Then there was a 2011 study called The Economic Contribution of Copyright-Based Industries in South Africa by Professor Porras of the Pretoria University, and that is part of a compilation of national studies that was compiled for the World Intellectual Property Organization. The purpose of the study was to look at to estimate the economic contribution of copyright-based industries. In the conclusion of this report, the author gratuitously gave his personal opinion on the desirability of new copyright exceptions. His recommendations was based on a recommendation of a committee in the United Kingdom, and that recommendation was never implemented in the United Kingdom. So the main body of this study does not contain any impact assessment of new exceptions or any conclusion. So there was another study by the same author in 2009 that was based only on library community input, and it suggested exceptions for visually impaired persons, extension of the personal use exception, and exception for format shifting. None of these are contentious, but we have found that the bill's drafting of these exceptions can be much improved. In 2014, there was another assessment done by a company called Genesis Analytics, and it was an assessment on the draft national policy on intellectual property that was abandoned eventually. There were two versions of this study. The correct version was submitted the 6th of August. It's important to mention that because it replaced an earlier version that was submitted a week before. So the correct version is the one of 6th August. This assessment makes 3 recommendations for copyright exceptions: expanding existing exceptions for teaching, allowing parallel importation for education purposes, and introducing statutory licenses for reproductions and translations for developing countries. It says that a sufficient case for fair use has not been made out. So none of these studies support fair use. All of these studies predate the bill by 3 to 8 years. And none of them suggest text for the bills, and none of them can really classify as proper socioeconomic studies. So if we look at this, it undermines the claim that these studies have been done, and it is pretty much accepted that the trade industry did not follow the intergovernmental socioeconomic impact assessment system. And there's no proper underlying policy for following fair use or the hybrid fair use. We couldn't find any published policy document that backs this. Everything that was mentioned about it came only after the bill was published. So for these reasons, we came to the conclusion that the bills run a very high risk of being unconstitutional, and it is very likely to be found unconstitutional in the Constitutional Court. And because of what is possible before in this process, before the National Council of Provinces and the legislature, we cannot come to the conclusion. The only conclusion we can come to is that the bill must be rejected, and that it must be let to lapse. And we have made proposals. So our submissions contain proposals of a way to take this forward so that the reform can actually happen.
Thank you very much. I appreciate that. So we do have another 2 guests who are TBC, but we'll just check if they are with us. The first is Adrian Galley from the South African Guild of Actors. Is Adrian in person or possibly online? Just give it a moment. Okay, no Adrian. The next person was Molife Kumona from GQ Magazine. No Molife. All right, we'll move on to Nhlanhla Paul Sibisi from RISA and IFPI. I believe that Nhlanhla is here in person.
Yes, I am, Chair, and good evening. Thank you for the opportunity. Members, colleagues, I guess when one listens, Chair, to most of the submissions, they indicate perhaps the failure, in my view, of the department in conducting an industry-based study in each of the copyright sectors. I think, Chair, maybe let me take us a bit back. I was part of the Standing Advisory Committee, which was headed by Judge Falam. The advisory committee was advising the Minister of Trade and Industry at the time. Most of the legislation and the amendments that were made to copyright in particular were often as a result of some in-depth investigation done by that committee. Over a period of at least 10 to 15 years, the input by the committee started not making any impact. And perhaps that explains why the Section 40 Advisory Committee is not active at the moment. Following that, Judge Falam was in charge of the Copyright Review Task Team, which was particularly focused on payment of royalties by broadcasters to collecting societies, from collecting societies to producers as well as performers in the music industry. So the start of the amendments to the Copyright Act really started that time, in 2010, 2011. So there was an in-depth discussion, investigation by that task team. Recommendations were made by that task team, but they were focused in the main on the music industry. The fact that there are so many other sectors in the copyright sector, or in the copyright industry, that were not looked into by the department explains why we are finding ourselves in this situation where you have each sector raising an issue about the bills, but most importantly, the bills trying to do what is called a one-size-fits-all. If we look at the change in policy as another example, from fair dealing to fair use, it was not supported by any investigation, not supported by market failure, which then would have resulted in us saying we probably need to change from fair dealing to fair use. So all of those failures are starting to come out as we debate the bills as the various sectors. I don't think, if I look at the music industry in particular, I don't think we are saying the act should not be amended. That's not what the sector is saying. We are also not saying royalties should not be paid. And in fact, we've been pushing for the alignment with the WIPO Performances and Phonograms Treaty, which is clear in terms of payment of royalties. We have pushed for the alignment with WIPO copyright treaties. So that's not an industry that is trying to refuse musicians payment of royalties. That's not what we are doing. We are more worried about the unintended consequences of those bills. I'll give you a practical example. In the performance protection, there's a 25-year reversion on the performer's consent to a sound recording. That's unscrambling the egg. So what we are saying in terms of the bill is that after 25 years, the performers then retain, or the consent reverts to the performer. But the copyright owner still owns the copyright in the sound recording. Now, what it means practically is that the performers must amongst themselves, and remember the performers include session musicians, backing vocalists, and the featured artist. They are all remunerated differently. Now they have to sit and agree on a royalty that they would go back to the copyright owner and propose. Now, if a session musician says, no, I want the same amount as a featured performer, that means that recording can be used. So coming back to Netflix, if that recording had been licensed to Netflix, I'm not sure what they're going to do with it, because if one performer, it only takes one to say no, and the recording can be used. And because we rely on recordings, that essentially means composers are not going to be paid any royalties. Publishers are not going to be paid any royalties. Record companies are not going to be paid any. The very performers that we are worried about are not going to be paid any royalties. So that's to me the simplest way of seeing how disconnected some of the suggestions, the proposed amendments are to the actual reality of the industries. Because if one understood that by making the performers consent to revert, you are essentially suggesting that there may be a problem in the future. And you are not providing a solution as to what happens if the performers and the record company that owns the sound recording do not agree. And that recording at that time, I mean, we have the long tail when it comes to consumption of recordings these days. You would see on YouTube, Spotify, Deezer, that songs that were released 50 years ago are being consumed. What are we saying about South African creatives in the recording space? Why are we not engaging with the sectors so that we understand what the practical implication of those bills are? That's the one part. And then there's the unfettered discretion given to the minister to prescribe contractual terms. I've been involved, Chair, with Musician Union of South Africa back in the day. And we tried to engage on terms, contractual terms relating to artists. That conversation never ended. Now, I'm not sure how the minister will be able to prescribe contractual terms in an environment that is, if it's difficult to the music industry, you can be rest assured it is difficult across all the copyright-based sectors. So I think for me, it's understanding the practical implications of what is being proposed, taking into account the uniqueness of the sectors that are governed by the copyright legislation, and understanding why performance protection and the Copyright Act need to be looked at in a more sensible way so that the rights are balanced, so that we're able to come up with legislation that we can all feel, yes, you walk away in any negotiation feeling I should have gotten more, but at least you feel comfortable that the sector is protected, that both performers and the producers are protected. And yes, there's a third one, which is taking into account the users. I guess it's a balancing act. But in the end, I like what the good doctor has said. We have not even looked at AI. We know that computer programs are protected in terms of our current act. And we know precisely, I'm wrapping up. We know precisely what exclusive rights are granted in terms of computer programs. But it's also right that there are there's AI that can mimic exactly someone's vocal ability. Mercy Pakela, who presented earlier, her vocal art can in fact be mimicked by AI. What do we do in that case? What do you do with restaurants, hospitality sector, that then decide they're going to use only AI-generated content, only AI-generated recordings? So a large number of performers and record companies are likely to be excluded as a result. So, Chair, I think for me, we do need to make changes to the current act. Already we are forced to, based on the Blind SA case, to make changes. So let's take that opportunity and make the correct changes that would ensure creatives are protected across the various sectors, as well as the producers and the investment that producers make in creating content. And I think, Chair, I'll stop there.
Thank you very much. I appreciate it. Thank you for the submission as well. Our next submission will come from Chula Makamate. Chula is from SAMRO and the Copyright Coalition. And I believe Chula is here in person.
Yes, I am, Chair. Thank you. With the pressure of being the last speaker for the day. But I'll be as brief as I can. Thank you again for the opportunity. As I have been introduced, my name is Chula Makamate. I'm here wearing two hats, one from the Southern African Music Rights Organization. We are a CMO representing composers and authors both in Southern Africa and also through some complex bilateral agreements, composers and authors across the world. And my second hat is that of the chairperson of the Copyright Coalition of South Africa, which represents trade organizations and associations within the creative industry spanning across various subsectors, including music, the audiovisual sector, books, animation, and a number of other sectors. I think a lot has been said today, and I'm going to avoid repeating a lot of it because I think a lot of my colleagues have made a lot of valid points, and I think people are tired. Some of them were making presentations before the NCOP, before they came here as well. But I think just to give some background around SAMRO, we have over 134,000 members across the country that we represent. And in this province, there are just over 8,000 members that we represent. So we're representing the interests really of thousands of members across the country who will be impacted by these bills. And our members within the CCSA are employers who create employment opportunities for thousands of people within the creative industries across the country. I think for me, firstly, to articulate that we do recognize that the Copyright Act needs to be amended. It's an old piece of legislation. It is not fit for purpose for what's happening around the world, and it needs to be amended. The objectives are laudable. We support them. And it's important that some of them be implemented, not necessarily in the legislation itself. We need to look at them and see where the changes need to be made, whether it's legislation, policy, sector, interventions, whatever the case may be, but you need to look at it quite closely. However, the devil is in the detail. And that's where things have gone horribly wrong with regards to this Copyright Amendment Bill and also the Performance Protection Amendment Bill. I mean, I liken it to, for instance, waking up and there's a problem in sports, let's say specifically cricket. And there's consultations that take place, and the department that's dealing with sports decides, you know what, let's amend some piece of legislation that will deal with sports in general, but applying the principles that deal with cricket specifically. And they do so, and we have a wonderful piece of legislation, or they think so. And then all of a sudden, the interventions for cricket are suddenly applied to rugby and hockey and basketball and netball and all these other sporting codes, but they are specific to cricket. And everybody now must adjust to having cricket rules applied to their specific sporting codes. It won't work. And that's what's happened with this bill. I think there was a knee-jerk reaction to what was happening specifically in the music industry and the problems there. And the bill has been drafted in such a way that it speaks to that, but is applicable across the board. And that's not going to work for the creative industries as a whole. In fact, you can just imagine somebody playing netball and now they have to use a cricket bat. somebody playing hockey and they have to use a netball. It just doesn't, it won't work. And that's what's going to happen with this bill, is that it's not fit for purpose for the creative industries as a whole. So the objectives that they're looking to achieve, or government is looking to achieve in dealing with the issues of the past, and dealing with remuneration, and dealing with sector problems, and dealing with contracts, are not going to be dealt with appropriately, because the solution that is being that has been created is not fit for purpose for our country. Fair use, we're importing something from the States. It works in the States, great. But if you actually look at the text, what we're trying to import into our legislation goes even further than what's in the US legislation. Never mind that it's a bastardized version of what's supposed to be, because now you've got a hybrid. Pick one or the other, like my colleague said. So our proposal is keep the fair dealing, but expand on what's in the fair dealing. Because what happens then is that the playing field is leveled, and we all know the rules. If you import this, none of us will know what the rules of the game are. So essentially, we'll be playing cricket in a soccer match, in a netball match, in a hockey match, or whatever the case may be, and there'll just be chaos. What will also happen is that, which brings uncertainty in our legislation, which will then impact how investors approach South Africa, because that's important. People need to understand what the rules of the game in a country are in order to invest in it. And that this legislation is going to create that uncertainty in our law. Another thing that's going to happen is that there's going to be an increase in litigation, because what happens when people don't know what the rules are? You need an arbiter to decide for you what the rules are. You're going to force creatives in this country to have to approach the courts to make decisions about what fair use is, or whether there is an infringement. And because we've now imported one thing and not the other, we would have the fair use, or hybrid, whatever it is, but you won't have the similar punitive statutory provisions that are in the US law in our law. So the most you get in terms of damages would be what you would have gotten in any event for a license fee, which is minimal. So you bring this thing in, but you're not bringing the added protection that's required for that. So there are a lot of things that my colleagues have picked up or have articulated about what's wrong with the bill as it stands. And they need to be looked at. We're not saying, some people say scrap it altogether. That's one option. Some people say you can fix it with regulation. I don't think you can fix it with regulation. There are lots of things that are being put on the table. But the issue, I think, and Nhlanhla raised it, is that the core of the matter is that there wasn't an economic impact assessment study done to ascertain how this bill would impact the various sectors. Because there's a lot of, and I think in this room and other rooms, a lot of emotive language being used, a lot of conclusions being reached about the bills. But what is the basis upon which the bills were drafted? What is the underlying policy? What is the underlying impact assessment study? What are we basing a lot of these provisions on? We don't know. The DTIC is not able to articulate to us what they've based this on. Hence this huge disjuncture amongst the various sectors about what we need to do, because we are not placing objective standards and objective studies in front of the stakeholders to indicate exactly how decisions were arrived at. And that is where the irrationality comes into play, and that is where the disjuncture comes into play. And that is why you have such a divisive bill. I think in recent history, this is the most divisive bill that we've seen come across Parliament, because it's as clear as mud in most instances, and there's no guidance, and we don't have a North Star to guide us in terms of where we're going. And I think that's very important, that needs to be looked at. So again, the devil is in the detail. Can we please have an economic impact assessment study? Can we please speak to or get advice from a broad grouping of experts and not just one set of experts? Because I think that's another challenge that's happened with the drafting of this bill. There seems to be an ear to specific experts and not listening to people who can give a broader picture, a full picture of how to approach copyright, so that we remain competitive with the rest of the world, and we protect our creatives. Because if you pass this bill as it is, you will do the exact reverse. Our creatives, so government claims that they're trying to protect, will be left naked. They'll be left unprotected. They'll be left unable to assert their rights and protect themselves in terms of the current legislation as it is. So my plea is to look at the detail, to listen to the experts, to have the proper policy documents, the proper impact assessment studies in front of you, so that you're able to make an objective decision about what to do with the bills. And that way, you will make sure that it's future-proof. I mean, AI is not new, but it's impacting us. I mean, your counterparts in Europe and the US now are discussing how to regulate AI. We're having, from that perspective, rudimentary discussions in this room. that's where everybody else is at, and we're not even prepared. We can't even have that conversation because we're struggling to deal with the basics of operationalizing copyright as it is currently in our country. So, you know, for me, that's just our input from our side is make sure you have the studies in place, make sure you have the policy documents in place, make sure that there's proper consultation and not just tick boxing exercises when you engage stakeholders, and make sure that you take into account the views that are placed before you, and it should be reflected in the drafts that come through with the Copyright Amendment Bill. Thank you, Chair.
Thank you very much, Chola. I understand that we do have Adrian Galley in the room. Hi, Adrian. We called on you earlier to do your presentation. Okay, we can.
Shall I put that on? Is that better?
We can try and flight the presentation from our side, but just so you know, everybody has a copy of your presentation, so you can just go right ahead.
Oh.
Should...
Okay, let me just read what I have here, but I do also have it on here. Front, I think.
Okay, we'll get the presentation up and you can start so long.
Okay. Good evening, Madam Chair and committee members. My name is Adrian Galley. I'm an actor, and my script is not showing here because I've got the pictures. If you could just bear with me for a second. How do I get out of this? Let's try that again. My name is Adrian Galley. I'm an actor. It's a great privilege to make my oral submission on behalf of SAGA in accordance with my mandate as Vice Chair. I'm grateful for this stakeholder engagement. As an exercise of the democratic process, I appreciate that this is an opportunity to hear from all interested parties. I have studied and practiced my craft as a freelance performer for just on 40 years, believe it or not. And my reality, like all freelance performers, is that if I don't work, I do not earn. Before the COVID pandemic, I worked most consistently at the Fugard Theatre, but sadly, that establishment was forced to close its doors for good. I therefore find myself more available for presentations such as this one. I understand this round of public hearings comes as a result of the draft legislation being re-tagged as Section 76 bills and seeks to ascertain the possible impact they'd have on the province should they be passed into law. I'll therefore constrain my presentation to those aspects of the bills that have a direct impact on the functioning of the Western Cape economy and, of course, the ability of myself and my colleagues to earn our livings within it. As it is well known, South Africa has one of the most worker-friendly labour regimes anywhere in the world. But freelance performers do not benefit from any of the raft of labour protections. This is simply because our current status in law, along with many others in the creative economy, is that of independent contractors. So when it comes to actors, we're independent contractors, there is no labour protection. So in essence, we are small business owners. With no recourse to labour protections, all the work we do is governed by contract. Of course, freedom of contract is the cornerstone of any modern business environment. Unfortunately for freelance actors, freedom of contract is something of an illusion. The reality is that performers are subject to an imbalance of bargaining power and are typically offered contractual terms they have no right to negotiate. Each of us, small business owners, is alone in the struggle. Any attempt to organize a forum where we can collectively share our concerns is met with sanction from the Competition Commission. As independent contractors, any discussions we undertake with our other stakeholders is considered collusive behavior. Any resolutions taken during such engagements are classed as anti-competitive and thus illegal. And SAGA has first-hand experience of being jumped on by the Competition Commission for just that reason. Hollywood actors have enjoyed collective bargaining rights since the 1930s. So what's the difference there? We compete with Hollywood performers on a global scale, but they're not subject to the same restrictions that we are. The bills under review offer some sort of statutory regulation within the creative sector, but before I venture into speculation as to how actors stand to benefit, I'd like to explore the impact of regulation in the business environment. Regulation provides investor confidence by defining the rights and responsibilities of employers and worker groups under a policy framework that offers uniformity and certainty. Regulation offers predictability and a vision of a shared future of the industry. Most importantly, it allows all parties to share an equitable stake as partners in a sector that can have a sustainable future. We have a right to earn. It doesn't bear mentioning that had actor royalties been secured in statute decades ago, many performers who've passed on, who remain household names even today, may have had a fighting chance of keeping poverty at bay. We must never forget how such legends as the late Henry Tele, Joe Mafela, Menzi Ngubane, not to mention Mary Twala, Elise Kaywood, and others, who have not seen a single cent of the earnings that producers and broadcasters continue to gather today, even as the work is licensed and viewed across the world. Now, let's not forget Charlene Surtee Richards, of course. I do have a slide of her, so I'm sure we can conjure up an image of her too. SAGA did not invent royalty rights for actors. It's a well-established industry norm practiced around the world. It's a mechanism by which Morgan Freeman from the United States can earn royalties for his portrayal of Nelson Mandela. So you would be right to feel outraged that South African actors working alongside Mr. Freeman do not qualify for royalties. The Performance Protection Amendment Bill and the Copyright Act are intended to be read and interpreted together. Having learnt from the experience of musicians who report that their royalties have been stolen, it makes sense the CAB and the PPAB have linked so that royalty right for actors can be supported by a mechanism by which royalties can be calculated and distributed by a collective management organization dedicated to the audiovisual sector. SAGA's participated in every parliamentary stakeholder engagement process since the bills were introduced to the National Assembly in 2017, and in the 6 years intervening, it is alarming how many stakeholders seem to have lost track of why the bills were drafted in the first place. And it seems abundantly clear that some of the stakeholder submissions that have been heard, that many have failed to move on since 1967, when the Performance Protection Act came into being. Time and technology have moved on, but the laws that were intended to protect performer interests have remained anchored to an era that we should have long outgrown as a nation. Similarly, the Copyright Act of 1978 is out of step with technology and with fair earning rights of performers in the modern era. Let's be frank, those apartheid-era laws remain in effect today, and this should concern every South African with a moral conscience. There have been grossly ill-informed assertions made in various forums by detractors of the bills that if we are to seriously embrace the project of transformation, we need to call out these obstacles to our progress. For example, we hear arguments to suggest the bills conflict with obligations under international treaties to which South Africa hopes to accede. On the contrary, the bills are firmly rooted in the Berne Convention. They're aligned with provisions of WPPT, TRIPS, the Marrakesh and Beijing treaties, In fact, the legislature has incorporated provisions of the Beijing Treaty on Audiovisual Performance into the draft legislation under review. In doing so, the legislature has recognized the necessity of these protections and chooses to recognize the binding nature of this international law. Another contention that begs a rebuttal is that the bills permit background performers or extras to earn royalties. In fact, extras do not sign performer contracts, nor do they trade on their image or performance skill. The Beijing Treaty itself is clear that it does not provide a royalty earning right to extras, a fact which many opponents of the bill seem to studiously ignore. This particular strawman has been deployed to tear down a number of provisions in the bills. The rationale, of course, is that the definition of performer is too vague and too broad. Well, the definition in the bills is consistent with the one contained in the Beijing Treaty, which expressly is interpreted to exclude background extras. The naysayers further decry the authority delegated to the minister. We submit that in a fast-evolving digital realm, the flexibility of the legislation to adapt to new challenges must be welcomed and embraced. Passing this draft legislation will provide performers with some form of protection against exploitation. This is so because when negotiating with producers, broadcasters, and streaming platforms, they'll be able to assert their rights in terms of Section 3A of the revised Act to ensure that they're fairly remunerated or receive royalties for their performances. In arguing against this provision, together with Section 8A of the CAB, it's been incorrectly claimed that there is an immutable right to royalty with no option of offering a buyout in respect of the actor's exclusive rights. Well, this is another fallacy. While the CAB itself makes no mention of equitable remuneration, Section 8A is clear that the royalty provision is subject to the PPAB. And the PPAB, in the preamble itself, is explicit that royalties and equitable remuneration are interchangeable, and the phrase is in fact used no less than 14 times in the provisions that follow. The Western Cape, as we know, is the nexus of large-scale audiovisual production. Many of us, I say, I don't know about you people, but we've been able to practice our craft alongside our international counterparts in such series as Black Sails, Warrior, Raised by Wolves, just to name a few. As with the case I mentioned earlier involving Mr. Morgan Freeman, no local actor is entitled to any form.
If you can just begin to wrap up, thank you.
I beg your pardon?
If you can begin to wrap up, thank you. Exceeded the 10 minutes.
I did?
Yes, you were very much caught up in it.
I'm right at the end here. So I just wanted to say that no local actor in any of that work has had the right to receive royalties, and it should not come as a surprise that many have since left our shores because they were recognized in these projects, and we've lost them to our province and to the industry. Actor royalties have been shown to create a more stable and predictable system. This is based on Hollywood, who've got nearly a century's worth of data. It allows them to focus on their craft, invest in their careers over the long term. It also assures that they have ongoing financial interest in the success of their films. What's more, the right to earn royalties has been able to motivate actors to take on roles in smaller, riskier films that might not have substantial upfront pay. This leads to innovation and a more diverse range of films being produced, including independent art house films that might not otherwise have been made. Now, reports indicate Hollywood's currently the largest income-granting film industry in the world. It's been almost that for a century. According to the Motion Picture Association, global box office reached a record of $42.2 billion in 2019. Hollywood Reporter's annual box office reports for 2019 also shows Hollywood was the highest grossing film industry in the world, with domestic box office returns totaling $11.4 billion, followed by China at $9.2 billion. Perhaps more revealing, American films account for 73.7% of the global box office in total. Actor royalties do not seem to have done them much damage. I thank you for your kind attention, Madam Chair, and esteemed members of the committee. Thank you.
Thank you very much.
I had lovely pictures to show, but
we'll have to circulate them.
Too bad.
Thank you very much. So we have managed to get through all of the presentations. There has been one last final presentation added by SAMIC. If there is a representative from the SAMIC. Okay, nope, no one's present. All right, in that case, we do have 15 minutes left, and we can take... Is SAMIC online?
Yes, it's just try to
okay,
so that
fantastic.
that's when I have an opportunity. But maybe without wasting time, I'd say thank you for the opportunity. And I think some of our colleagues from the music industry space have already put our position. We are against the fair use. You know, one of the challenges that one have been going through, listening to a number of presenters in various spaces around these bills, have been seeing people who are working for other corporate companies who are earning salaries every month, telling people who are in the arts, creatives, that they should actually compromise or agree not to earn so that they can use their creativity, which is part of their work and livelihood, for them to be able to carry on earning. What do I mean? For example, some of the organizations have been people who are coming from the education environment, academics, who are, let's say they are lecturers or teachers. Every month they're getting salaries. But they want to argue that we in the creative space must agree that we shouldn't be paid, we shouldn't earn from our work, but we must give them, so they are not prepared themselves in it, where the country is talking about a free education. They are not prepared to teach without being paid salaries, but they want the people from the creative industry to compromise their livelihood for them. I find that to be something that has been very strange. But at the same time, like we said, that the bills, they're basically trying to address too many things, trying to please different sectors that don't operate in the same way, you know. At the end of the day, somewhere we basically all relate to one another. I mean, for example, in the film industry, we work with the film industry. We respect how the film industry operates, but the music industry is not the same. The same way as I've been saying that, you know, a lot of artists have been contributing positively to their communities. If somebody approaches you to say, we would like to use your work, but we cannot afford paying royalties for it, you know, a lot of artists have availed their work towards contributing towards the development of society. Now, I don't know why then people have a challenge of the fact that we say that if you want to use our work, come to us, respect our rights. I mean, if we agree, we will agree, because on the one hand is we have a lot of capitalists that stand a lot to gain, and they are hiding behind education or making content available to help the disabled and all. They are hiding behind that cause because yes, it's a touchy cause and we all support the disabled community, but the challenge is when we agree in a blanket way that fair use must happen, it's the largest people who are going to be abusing it are the capitalists. So it is in this light that us as the South African Music Industry Council, which is made up of over 23 organizations that includes musicians unions of South Africa, it includes independent record company owners, it includes collecting societies. So it's the whole music industry that I represent. And we're all saying we are against fair use. I thank you.
Thank you very much. So I want to thank everybody who's joined us today. We are quite short on time, and I do understand that we have representatives from .P and Westgrow who would like to make their representations. Can I ask if you'd consider submitting them in writing, or if you would be willing to speak extremely briefly to them and also make a submission in writing? Any feedback?
Pardon me, Chair, could you repeat that?
So I understand. Okay, it's not Westgrow, it's the Commercial Producers Association as well as .P, so the Department of the Premier, who asked if they could make submissions. We are short on time. We have 8 minutes left, and we do need to allow some people to transport back home. So if you do still want to speak, if I can ask that you be extremely brief. Otherwise, if you could please make your submission in writing, consider doing that as well.
We can be extremely brief. It's actually Bobby, our chair, who's online, who's going to make the presentation.
Hi, yes, thank you so much. I'd also like to just invite my colleague Trish Darling, who is from the Independent Producers Organisation, to come on, and she will give a very brief intro, and I will just finish off. We won't take a lot of your time, and we thank you for accommodating us. Trish?
Thank you so much for accommodating us. We're deeply grateful for this opportunity, because these bills will have a profound impact on the industry, not just on the audiovisual sector, but we believe on the entire creative industries. We have heard so many comments tonight that have resonated with everything that I've learned in my 3 years of studying these bills, and that is that they are profoundly imperfect. A one-size-fits-all approach in a sector that is so vastly different as the creative industries simply cannot work. I loved Chola's analogy about the sports regulations. It was absolutely perfect. We have a challenge of a lack of socioeconomic impact assessment study. Despite being told repeatedly there was one, this has never been published. What's on the PMG website is an unsigned Word document, and it doesn't take into account exceptions and provisions that were introduced after that very inadequate document was created. The film industry is entirely unique, not just unique to other sectors, but unique within itself. It spans a myriad of productions, from small first-time filmmaker productions on incredibly low budgets and borrowed money from parents, all the way through to the big international productions that we see and have heard about in other presentations. The life cycle of a film it can be years in development, months in pre-production, a very short period of shooting, and a very long period thereafter of post-production and distribution before a cent gets realized. So producers, if you think of this last James Cameron film, the Avatar sequel, he's been working on that for over 10 years. That is the lifespan. Whereas the performers who are asking for royalties come in a very short little shooting period of that. And they're wanting, as Adrian Galley said, an equal share. Is it fair for someone who's worked for 3 days or 3 weeks on a film to attract an equal share for someone who has worked for conceivably 10 years, investing their own time and their own money in developing that? The big problem, and what hasn't been addressed, a lot of our challenges have been raised already. A a big challenge is that the unintended economic consequences have not been considered or addressed. The 25-year rights reversion means nobody is going to want to invest in something. Why would you invest in something which you can only commercialize for 25 years? Rather go and spend your 10 million investment on a house in Clifton, which will appreciate in value. And there is little risk to that compared to the risk that exists in the film industry. We urge this committee to please consider our submissions, which will be delivered by the 10th, with due consideration for the economic impact. And that impact will not just be felt on producers, it will not just be felt on actors who will experience less work. And as someone said earlier, a royalty on nothing is nothing. It will be felt in the province and in the country, because this is a sector that has so much to contribute to the economy and to jobs in this country. And these bills, if passed, will have a massively stifling effect on the industry and broadly on the creative industries. I hand over to my colleague from the advertising sector.
Apologies, we really do need to cut it short over there. But if you could please make your submission as well in writing, we would really appreciate that. I would just like to offer the Department of the Premier an opportunity if they'd like to make a short remark on their submission.
Sorry, thank you very much. We will be submitting a written input. Thank you.
Thank you very much. I do appreciate that. My apologies to all who've attended today and who did want to make a submission. We have unfortunately had so much interest, or fortunately had so much interest, that we haven't been able to listen to everybody today and certainly give you as much time as you might have liked. But of course, written submissions are just as important as oral submissions. So if you do send those through, please do so before the 10th of March. That's our cutoff date. And we would really appreciate it. My business card is here if you'd like to take that and send it through to us as well. Then just to wrap up, this is our final hearing. So thank you for being a part of this. This has been quite a process, and I think my colleagues over here will tell you that it's been quite tiring. We've been all over the province listening to what residents feel and think about these bills. So we now have to apply our mind to that. We're going to put together a matrices based on all the submissions that we've received, and then that will inform a negotiating mandate, which will go to the NCOP. I've noted that there have been some questions and some comments which have come through online. Just to those online who have put through questions and comments, we will be sending those questions through to DTIC and ensure that you get a response to those questions. They've kindly offered to take you up on responding to those questions. And I also just wanted to note that there are refreshments in the members lounge if you go to the back. And for those who've arrived from Piketberg, we've also arranged transport back for you. So please don't miss your bus. Thank you, everybody, and travel safely.
Thank you, Chair.
Thank you, Chair.